Good
Good
morning. This
morning.
is the Energy and Carbon Management Commission. It is Wednesday, June 25th. It is 10 a.m. and this is our normal business agenda. We'll start with the roll call. Hearing Officer Smeltz.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here.
You have 5 of 5 commissioners present.
Fantastic. Good to see everybody. Next, we have commissioner comments. I've got one comment, or two. Yesterday, we held our all hands meeting at the commission, and most of all of ECMC showed up in Denver, and we had a nice afternoon with everybody. It's always good to get together and be together. I also was invited to attend the Colorado Attorney General award ceremony, and I'm pleased to announce that the Energy and Carbon Management Commission received an award that goes to a client of the AAG for operating in a spirit of partnership, engagement, and creativity with the Department of Law to achieve an important outcome. That's really cool. The Attorney General's office recognized the work that we've done. A lot of it was the engagement that we continue to do with the Attorney Generals and the Resource Conservation Unit. We engaged them to assist us with all of the rulemakings that we did over the course of the last year, and they pointed out that that is a really good attorney-client relationship, and that I believe our utilization of our attorney generals indeed allows us to do all of the great work that we're doing. So I do believe it was a great outcome for the state of Colorado. Director Julie Murphy and I attended and received that award on behalf of the commission. We'll make sure it's prominently displayed somewhere in our main offices so that everybody can see it. So pretty cool. Good to be recognized for the good hard work that we're all doing. Are there other commissioner comments? Seeing none, we move to general public comment. I note that one Devon Reynolds had signed up. Is Mr. Reynolds in the panel? Hearing Officer Smeltz, do you see Mr. Reynolds by chance?
Hi.
Oh, I'm sorry. Hello,
Hi.
Ms.
They've been
Reynolds.
elevated.
Hey, Ms. Reynolds, you signed up, and in signing up, you indicated you wanted to speak to the Wild Earth Guardian petition.
Correct.
We're happy to hear you for 3 minutes, but I did want you to know that we're having a special public meeting on that petition on July 30th, and we will be taking public comment at that time. And so if you wanted to wait and do your comments then, that would be appropriate. If you want to go ahead and give it to us now, we'll try to remember them between now and July 30th. Your choice.
Here, I'll go ahead and do it now, and I'll be at that meeting as well. So thanks for letting me know. Are you ready?
Yeah, go ahead.
Okay. Well, thank you for your time today. I'm Dr. Devin Reynolds, representing Colorado Communities for Climate Action. We are a coalition of 45 local governments across the state, advocating for stronger state and federal climate policy. And collectively, we represent 1/3 of Colorado's population. And as you know, I'm commenting on this petition for a rulemaking brought by Wild Earth Guardians and a large coalition of other petitioners. The petition presents reasonable evidence of insufficient accounting for greenhouse gas emissions from new oil and gas sites. The cumulative impacts reports that this commission currently mandates in applications for new wells are intended to provide fact-based estimates of greenhouse gas emissions expected at these new extraction sites. However, the petitioners have shown that the estimates have in fact been inconsistent and incomplete as currently reported. So we're seeing that this means a reconsideration of the initial cumulative impacts rules is in order so that we can learn from this experience and refine reporting requirements that will ensure completeness and accuracy of these reports. As I'm sure you're aware, this commission needs this proper accounting of greenhouse gases in order to make science-based permitting decisions that incorporate cumulative impacts, and that's mandated by state statute as well as supported by science. And local governments also need this information. We are tasked with protecting our residents and reducing greenhouse gases in our own jurisdictions. And we need this accurate information in order to communicate with our residents and to fully understand the emissions that we can expect to be occurring within our city and county limits. I'd like to note that local government representatives from Adams County, Broomfield County, Town of Erie, and Boulder County have already written comments in support of accepting this rulemaking request. As you continue to mull this topic over, please consider these comments, and on behalf of CC4CA's membership, I'm reiterating that support and asking the Commission to approve that sensible request for rulemaking. Thanks for all your engagement on this topic.
Thank you very much. And thanks for being with us this morning. We look forward to considering that matter on July 30th. We now move to consent agenda. Does anyone have questions on consent? Seeing none, do we have a motion to approve consent?
So moved. Second.
Motion and a second to approve consent. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? That motion carries. We now move to a report. It's the annual cumulative impacts report. It's going to be presented to us by Sabrina Trask, ECMC Cumulative Impacts and Energy Transition Manager, as well as Stephen Schwartz, ECMC Cumulative Impacts Supervisor. Good morning to you both.
Good morning, Commissioners.
Good morning, Commissioners. Thank you for having us. For the record, I'm Sabrina Trask. I manage ECMC's Cumulative Impacts and Energy Transition Unit. I asked my colleague, Stephen Schwartz, to join me this morning. I'm going to confess I've been on annual leave the last 2 weeks and not very well prepared to be the primary presenter of today's presentation, so I've asked Stephen to step up. I will be here to provide support and to help answer any questions after his presentation today.
And for the record, I'm Stephen Schwartz, the Cumulative Impacts Supervisor within the Cumulative Impacts and Energy Transition Unit here at ECMC. Let me share my screen. Alrighty. You can all see my presentation in presentation mode, correct? I see
Yes.
nodding heads. Alrighty, well, thank you very much, Commissioners. I'm, again, Stephen Schwartz, Cumulative Impacts Supervisor, and I'm here today to discuss some of the findings and report to you on the 2024 Annual Report on Cumulative Impacts. So the agenda for my talk today, I'm going to sort of start with a state of the oil and gas in Colorado in 2024, recap the number of OGDPs and locations that were approved, as well as show where these were throughout the state. Go into a little bit of a summary of air quality. This is a sort of a summary of the contributions by our partners at CDPHE regarding greenhouse gas, as well as ozone, focused specifically on the oil and gas contributions therein. And then go into a subset of some of the major conclusions from the 2024 report, focusing on conclusions around water usage, citing within the changes within the Front Range, citing changes within DI communities, and then a final conclusion around the informed consent 604B off-ramp. Then we'll look towards the future of the report and cumulative impacts in Colorado, wrap up with some recommendations, and leave some time at the end for questions on future report topics. So what was approved in 2024? So in 2024, there were 58 oil and gas development plans approved. This is an increase from the 45 that were approved in 2023. And this, because you can have more than one location within an OGDP, there were 117 OGDP locations approved in 2024, an increase from the 71 approved in 2023. The map on the right there shows where the 2024 locations were in comparison to the previous locations from years 21, 22, and 23. As you can see, similar areas of activity in the West Slope, the helium projects in the Southeast Plains, as well as in the Front Range, but a few new areas in the Eastern Plains, as well as our first OGDP locations within Jackson County up in the North Park Basin. So going into air quality, and this is sort of a abbreviated summary of the great work of the contributions our CPHE partners provided for this report. Starting with the greenhouse gas inventory. So the Greenhouse Gas Roadmap 2.0 was released in 2024, containing updated models as well as 49 additional near-term actions. This updated greenhouse gas estimates for oil and gas indicated that the state is in fact closer to achieving these greenhouse reduction targets than previously estimated, and the oil and gas sector in particular is expected to achieve its emissions reduction targets. The chart on the right shows the historical greenhouse gas contributions as well as the business as usual in the blue line, the roadmap baseline scenario, as well as near-term actions projections, as well as the targets for 2025 and 2030, showing us on track to be even below the targets that were set. Moving on from greenhouse gas to ozone, a quick summary of the 2024 ozone season. Again, this is the May 1st through September 30th is the ozone season. Saw an increase in the high ozone days compared to 2023. Some causes for this were unseasonably hot and dry start with precipitation over 150% below normal. Very hot and dry start if we recall last summer. In July, we had out-of-state wildfire smoke contributing to ozone concentrations, and the ozone season in general just remained hot throughout August. You can see the chart on the right, the number of days above the 2015 ozone NACS, so that's the greater than 70 ppb for ozone. And focusing in more specifically on what are the contributions of oil and gas to these ozone trends, AQCC approved measures to reduce the oil and gas emissions in its December 2023 rulemaking. This included things such as the in-use requirements for non-road engines, for drilling completions throughout the non-attainment area during ozone season, establishment of a NOx intensity program for the upstream oil and gas, which we have in the Cumulative Impacts Group presented to you twice already. This is the Form 2B, Form 2D as in dog, NOx intensity form that we have at ECMC. And finally, there were new emission standards on stationary engines statewide, including those for oil and gas operations. So this sort of wraps up the sort of summary of the contributions from our partners, though it's not an exhaustive summary from partners at CDPHE. And now I'm going to go into some of the conclusions that we were able to glean from the 2B data received over the past year. I want to start with the first conclusion is water usage comparisons are complex and need improvement. So for the methodology for doing the estimates to actuals for water usage from OGDPs, on the Form 2B, we receive the estimates of water usage the operators intend to use during their operations. And then the Form 5 and 5A provide the actual water volumes used in the operations. The Form 5 being the drilling report and the 5A being the completions report. Ideally, the estimates of the water usage provided in the Form 2B, which you can see in the upper right-hand corner, figure 5A, would match the actuals that we receive on the 5 and 5A. The reality that we saw from the locations that were fully drilled and completed in 2024, these most recent examples identify that the Front Range and West Slope show that the water usage is actually being underestimated. So that the value that we get on the 2B is less than the actuals that's being reported on the 5 and 5A. When we look at the estimated recycled water usage, we also see a slight disconnect. Most recent examples from locations in the Western Slope show that the recycled water usage is being overestimated. So what they're saying in the 2B for the recycled water use is more than what is actually being reported on the Forms 5 and 5A. Though one bright spot, it would appear that the front range estimates do appear to be in line with their actuals. So the calculations that is happening there is more in line for the estimates into the reality of the operations in the field. One takeaway here is that perhaps additional scrutiny of OGDPs in water stress areas for these water usage estimates may be prudent. And one future-looking statement here, recently completed produced water rulemaking will provide additional tools to understanding the water usage, particularly the recycled water usage. These new tools come in the form of the updated Form 7 and the Form 47 to understand these more specific details of water usage at these locations. And we look forward to incorporating this data in future reports starting in 2025. And just to give you more insights into some of the data we're using and why I'm saying, it's a segment of locations, there is a lag time between when the Form 2B is submitted and approved and when all of the Form 5 and 5As are submitted. We only use locations that have all of their wells drilled and completed and have the 5 and 5As approved through review by technical staff, so that we're using the publicly available data that anyone could use from our COGIS database. In 2024, a total of 20 locations were fully reported. This is 9 more than last year's report, so a bigger sample size than last year, but a small sample size overall still means that individual locations can have outsized outlier effects on the data. Here is an example of a subset from 4 different OGDPs in the West Slope. OGDPs 1 and 2 actually used more recycled water than they had initially estimated on their 2B, but OGDPs 3 and 4 used significantly less recycled water than they originally had estimated. This is the what, and we intend to spend the rest of calendar year 25 looking into some of the why. What are the challenges that operators are having turning the estimates into reality? Next conclusion I want to speak to you about today is front range operators reducing the density of oil and gas locations, but also maybe increasing impacts to wildlife. So one of the data fields we collect to understand the landscape of where these locations are being proposed are, what are the number of existing locations within a mile of the proposed OGDP locations? In 2024, front range locations saw a reduction in the number of existing oil and gas locations within a mile. Previous years in 21, 22, and 23 saw this average number of locations within a mile around 30. And we saw a reduction to about half that in 2024. Meaning that these were areas primarily that did not have a lot of existing oil and gas activity. However, 2024 also saw the most locations cited within HPH. You can see this in the graph on the left, with 44% of locations approved in 2024 being within HPH. And the majority of the HPH construction disturbance was in the front range, as you can see in figure 7G on the right, the front range being that 79% blue range. So looking in a little bit deeper, what is the source of these impacts? What is the factors of construction affecting the HPH locations? First, we looked at location disturbance. Figure 6P in the upper right is the average OGDP location disturbance in acres across all locations. And we see a modest increasing trend over the last 4 years for the front range, but not terribly significant. But we did see almost doubling the amount of location construction disturbance in HPH from 2023 to 2024. But this doesn't necessarily account for what we would expect to be that large increase. So we also look at not just the location construction disturbance, but also the infrastructure disturbance. So these are things like access roads, pipelines, utilities. And what we see is a significant increase from 2023 in the upper right in the front range, but also a significant increase in the acreage disturbance for these locations that are within these HPH areas. That's the figure 7V in the bottom right. So what is the cause of this increase of particularly infrastructure disturbance in HPH in the front range? There was an approval of a handful of very large multi-location OGDPs in areas that were very rural and had not had much oil and gas development previously. This necessitated the build out of the infrastructure to support these locations. built out of the access roads, built out of pipelines, built out of utilities to serve these locations. What were the HPHs that were impacted? And figure 7Z at the very top there, now it's a little small, but I think you can clearly see that the rural 1202D density habitats, casually think of them as because of the big game habitats, were the most affected in 2024 by disturbance. And when we look at the larger figure in the bottom, figure 7AB, the three most impacted species habitats in particular were the pronghorn winter concentration area being the most impacted, followed by the mule deer severe winter range and mule deer winter concentration area being the top three. Now, that's not to say that there were no mitigating efforts done. On the left-hand side, we have direct compensatory mitigation in the number of locations where this was proposed on top, and the dollar amounts that went along with this in the bottom, as well as the indirect compensatory mitigation on the right, again, number of locations on top, and then the dollar amounts in the bottom. So there is a significantly larger number of mitigation fees associated with this increase in HPH proposed disturbance. Now, sticking with the Front Range a little bit, we just talked about how moving from more oil and gas dense areas to less oil and gas dense areas. We also looked at the impacts to RBUs, and we found the Front Range operators are siting their locations further from RBUs. In this chart here, the Front Range is in the upper right-hand corner, and you can see that in previous years, the majority locations were in the 2,000 to 5,280 being the nearest RBU. And in 2024, for the first time, the most common distance to the nearest RBU was over a mile. This is a significant change and shows that the locations being proposed are being proposed further from RBUs on the average in the Front Range. This trend, you can also see when you look at the distance for what are the distance between the locations and the nearest RBU, even if that RBU is within a mile. And we can see the Front Range has been having their locations move further and further away to those nearest homes over the last 4 years. Another trend I want to speak to today is that in 2024, there were more locations cited in disproportionately impacted communities. However, one silver lining here is that they were further away from residents. So in 2024, there were more than twice the number of locations in DI communities compared to 2023. You can see this on the right here in figure 8.0. This is a steady increase since data started being collected in 2021. I will note Front Range had a similar 2024 to 2023, but we had new locations being proposed in DI communities that we hadn't previously seen. New in the Southeast Plains, new in the Eastern Plains, and an increase in the West Slope operating area. So we wanted to look and find why are we seeing this increase, especially in these newer areas. And one thing that we were able to tease out is that changes in the DI community definition that went into effect in 2023 meant that new areas are now DI communities that previously weren't. And the majority of the OGDPs approved in 2024 were submitted after this rule took effect. So if we look at 2019, I've highlighted 3 different areas in the West Slope, the Eastern Plains, and the Southeastern Plains. And on the right-hand side, we see the 2023 map. The red dots are the 2024 locations that are within DI communities. And you can see in the Western Slope, the switch in the different census blocks from what was to what now is considered DI communities. In the Southeastern Plains in Los Animas County, this is where all those helium projects are taking place primarily. You had Los Animas previously, only small parts were DI communities. Now practically the entire county is mapped as DI community. And then the Eastern Plains, a significant increase as well in areas that are now considered DI communities. Now, while there were more locations in disproportionately impacted communities, it's important to point out those locations in DI communities are an example of a positive statewide trend we're seeing of siting increasingly further from RBUs. Looking more specifically at the data, figure 8R here on the left is the average distance in the nearest RBU to the nearest RBU in locations in with a DI community. And we can see that over the last 4 years, that average distance to the nearest RBU is getting larger and larger. So the locations are on average getting further and further from RBUs in DI communities. Figure 8Q on the left is for all locations. There's a percent of locations greater than 2,000 feet from RBUs. While this is a more modest change, we are seeing an increase over time with more and more locations being sited further than 2,000 feet from RBUs. And the final conclusion I want to speak to you today about is informed consent is a well-rounded and effective permitting pathway. The 604B off-ramps were much discussed during mission change rulemaking, as well as during the most recent cumulative impacts and enhanced systems and practices rulemaking. We wanted to look at how these different off-ramps are being used. So just as a refresher, for the 604B off-ramps, 604B1 is informed consent. 604B2 is a location that received preliminary siting approval through a CAP or PSA through a CAP. 604B3 is, though the location may be closer than 2,000 feet to an RBU, the major equipment on that location is greater than 2,000 feet to that RBU. And then 604B4, that is the substantially equivalent off-ramp. So in 2024, informed consent was in fact the second most commonly used off-ramp, only behind the preliminary siting approval within a CAP. And when we look specifically within DI communities, informed consent was used twice as often as other off-ramps, indicating that this is the preferred off-ramp when the locations are within 2,000 feet of RBUs within DI communities. And I just want to note a little interesting statistical fact about 2024. There was one location in 2024, since it is a check all that apply for the off-ramps, that the location met both all 604B4 1, 2, and 3 for the same location. So looking forward to the future of cumulative impacts in Colorado and of the report in general. Want to focus on some updates on renewable energy. The deep geothermal rules were adopted by the Commission in August of 2024. This is an exciting carbon-free methodology for achieving energy in Colorado, and we look forward with our partners on the energy transition side of the Cumulative Impacts and Energy Transition Unit as that program continues to get up and running and grow. As well as within my own team, Renewable Energy Program Coordinator was hired earlier this year in accordance with SB 24212. Pete Dunleavy is who we hired, and he's working with representatives of local and tribal governments, assisting with project siting, planning, as well as coordinating a repository of model code. While ECMC does not regulate wind, solar, and battery storage projects, our experience with siting and bringing in Pete's expertise is helpful in providing that extra help for the different locales that are working to develop their own codes. I also wanted to talk about up and coming technologies that we observed over the course of 2024. And there's really a story here of pilot projects becoming standard operation procedures. Starting in the North Park OGDP that was approved in 2024, this included data processing cloud computing equipment planned within the OGDP for the beneficial reuse of the produced gas. Previously, this was retrofitted to existing locations in different pilot projects throughout the state. And it's encouraging to see this now being incorporated at the planning stage of an OGDP. Similar story, a Front Range operator previously had been incorporating temporary water recycling equipment as a pilot project to some of their approved locations, are now planning for this as part of their OGDPs. This system will allow the operator to derive 2.5% of the water for completions through this temporary system. While that might not seem like a large percentage in terms of overall volumes in the Front Range because of the long laterals and water usage, this is a significant volume of water that will be able to be used. And finally, I just wanted to touch on the methane emission reductions opportunities through the ECMC marginal well plugging program, which was launched this April, and not only through the MERT program, but also working with our Orphan Wells team to reduce the methane of these older wells is going to pay great dividends for cumulative impacts to the oil and gas industry for Colorado. So, focusing in on some of the recommendations from this year's report. First, seeking ways to expand ECMC reclamation staff, implementing work solutions related to reclamation, and expanding the gathering of cumulative impacts data. In terms of inspections, it was an impressive year for the reclamation team. 1,623 interim reclamation inspections and over 1,300 final reclamation inspections. Not all of these were one and done. Only 36% of those interim reclamation inspections ended with no corrective actions, while 75% of the final reclamation inspections did end with no corrective actions, returning this land back to surface owners and to previous standards. However, currently reclamation inspections don't capture acreage, and this prevents us from knowing what the extent of the current state of oil and gas disturbance acreage is in Colorado, since many of these locations predate the Form 2A when we started to capture that construction and interim reclamation acreage into our system. And while nearly 3,000 site inspections is very impressive, there are still thousands of locations awaiting final reclamation inspection, and the rate of inspection requests from operators outpaces the rate of inspections on an annual basis. The next recommendation I wanted to talk to you about is developing and implementing collaborative processes by which ECMC and CPW can track operators' payment of compensatory mitigation fees. This is pursuant to Rule 1203C. Currently, there's no shared platform to track if and when operators are complying with the rule requirement that they provide the payment to CPW 30 days prior to submitting the Form 42. And we look forward to working with our CPW partners to develop a shared data exchange going forward. Next recommendations, collaborating with other agencies, commissions, and consortiums to seek standardization of analytical areas. I've spoken a little bit about Front Range, Southeast, West Slope. The current CI report's operating areas are defined by county boundaries for easier data analysis, but we know that other groups use different definitions for their operating areas of the state. One example is Produced Water Commission using a more basin approach rather than county fixed boundaries. Collaborating with these partners will allow for mutual alignment and better data sharing going forward. A fourth recommendation is exploring ways to ensure regulatory processes can fairly accommodate new technologies and collaborative efforts that result in emission reductions and support the state's greenhouse gas goals. One positive example of this is recently ECMC worked collaboratively with the Colorado Division of Reclamation, Mining, and Safety, as well as CDPHE to identify various jurisdictional gaps, overlaps, uncertainty around the efficient permitting of coal mine methane projects. We know that this is likely not the last of these possible interagency, interdisciplinary projects, and we look forward to working with our partners on those future projects that would benefit from clear regulatory frameworks between the different agencies. Fifth recommendation, build a consistent approach to Form 2B data. In the past, there's been an inconsistent messaging provided to operators should the estimates, particularly around emissions, be best case scenarios that are only, you need the stars to align for them to achieve these estimates, or should they be overly conservative worst case scenarios that are easily surmounted by operators? One of the first steps staff is taking this recommendation already to heart is we are now fully staffed up with a recent hire of our cumulative impacts and emissions specialist, Dan Schoen, here into the cumulative impacts team. And we are going to be issuing clearer Form 2B guidance so that the methodologies and expectations from operators are understood and more consistent going forward. And we're aiming for later this year to have that guidance out and available. And then our final recommendations, develop further process and form improvements for the Form 2B. Recently, with the cumulative impacts and enhanced systems and practices rulemaking, there were multiple changes to the Form 2B to align with the new rules, but also some functionality changes, such as the ability to submit an amended Form 2B if there are changes that occur after Form 2B approval. Staff is going to issue guidance on this as well as to what are the times that it's appropriate to submit an amended Form 2B or not to take advantage of this functionality to better align estimates to actuals in the future. Seventh recommendation, a renewed focus on comparing Form 2B estimates to actual data. I spoke a lot in the beginning about the water estimates to actuals, but comparing the emissions estimate in the Form 2B to the actuals received by APCD through their ongoing program is critical to evaluating the accuracy of the data that's being provided to ECMC. Thus far, the mutual agencies' data sets unfortunately have not been in a position to foster this comparison. However, staff is well on the way to taking the first steps to achieving this. The Cumulative Impacts team has various members participating in multiple intra-agency work groups to better integrate data and is planning to work through the end of this year on determining what level of data comparison formally is possible. And we're prepared next year to come back if future rulemaking or form development is needed to achieve this outcome. And we look forward to presenting that in next year's report. And finally, more focus on minimizing impacts and maximizing outreach to DI communities. This recommendation comes out of seeing that significant increase in DI communities from 2023 to 2024. And one of the great things is coming out of the cumulative impacts and enhanced systems and practices rulemaking is the hiring and the initial first efforts by our community relations unit's environmental justice community liaisons. They have already hit the ground running, ensuring a higher quality of engagement by operators, not only through the materials providing in OGDPs, but also in their community outreach meetings. And the unit as a whole is working on a community outreach plan, as well as holding multiple various community outreach meetings. And so we feel that the unit, especially those new team members, are hard at work on that particular recommendation. And finally, I would be remiss if I didn't take some time to say some thank yous to all the people that made this report possible. Special thanks to, again, our community liaisons, the reclamation team and GIS team for all their inputs in this year's report. A huge thank you for our partners over at CDPHE, contributing authors and partners for good chunks of chapters 2 and 4, as well as CPW for their contributions to chapter 7, the wildlife focused chapter in our report. And of course, my most heartfelt thanks and deepest appreciation for my team. Alex Axe, technical editor, digital publisher, contributing editor, contributing author, and chief cat herder of all of us, keeping us on track for all of the deadlines and getting this first in-house report done happened without outside consultant work. Pete Dunleavy contributing for the renewable energy as well as other peer reviewer aspects of the report. Our air quality specialist, Dita Osborne, being the air quality section author and working in concert to get all those APCD sections into the report, as well as a peer reviewer throughout the report. Cumulative Impacts Energy Transition Manager, Sabrina Trask being a final editor and our fearless unit leader. And then last but most certainly not least, Mike Wells, who was our CIDR data wrangler and was the one who we can thank for all of our beautiful new graphs and charts for this year's report. I would now like to open it up for questions from the Commission, as well as have the opportunity to take ideas for future report topics. Specifically around the ideas for future report topics, we would ask today that you provide sort of general topics that you would like us to look into in next year's report. We would really like the opportunity to meet individually with commissioners to get into some of the more specific details about what you're seeing, would like to be seen within those topics, And then, of course, if it's desired, we can come back to the commission with that final list of topics that the commission will be formally requesting for the report next year. And that is it. And thank you very much.
All right. Thank you very much, Mr. Schwartz. Really appreciate all the great work that's gone into this report, which is very comprehensive. Commissioners, we have time for questions for Mr. Schwartz or Ms. Trask. Commissioner Ackerman?
Thanks. I really have just a couple of comments and suggestions, and thank you for the presentation. I appreciate that. And I would agree, great work from transitioning this from contractor to staff work. And I appreciate all the good work and the hiring of Dan to help ensure we're continuing to develop the report and use the report as the tool it's intended to be. I noticed, Stephen, that you left yourself off the people to be thanked list, so I wanted to add you to that list. Thank you for the great work that you've done. My other comment is that we saw through your presentation the continual push and pull between disturbing human environments and wildlife habitats, and something that we continually grapple with. We've pointed out in the past that we particularly have that push and pull when we're planning high intensity activities, either during wildlife wintering periods or during high intensity ozone periods, which really conflict with one another, and it makes for some narrow windows that we need to work within. So I wanted to emphasize that in each of the HPH developments, CPW has worked with the operator to minimize the impact, and the cumulative impacts report really does help us understand those trends. And I appreciate you pointing out the high priority habitat impact trends in this year's report. I'll certainly be watching and working for ways to continue to avoid impacts in those high priority habitats going forward. As far as items to potentially include, predictably, I wanted to talk just a little bit about high priority habitats. You mentioned comparing the 2B estimates to the actual data with air and water. I do think that there may be opportunities to do something like that with impacts to wildlife habitat, particularly high priority habitat. And I know that we often talk about minimizing the high intensity activities within those high priority habitats, particularly during the winter months. And I think it would be helpful to be able to understand in the end how many days of, I apologize for the passing sirens there, if you can hear them, for the, how many days construction, for example, or drilling or completions actually took place in those high priority habitats. And so including in the cumulative impacts report, not necessarily a breakdown of OGDP by OGDP, but the number of days of each of those activities that took place during the winter timing periods in HPH, I would find very helpful. Also, I think you alluded to this and you're already looking into it, but certainly wanted to reiterate the discussion that we had during the cumulative impacts rulemaking with regard to expansion of information of reclamation, and particularly if we can work towards understanding reclaimed acres versus disturbed acres, and as I mentioned previously, preferably by habitat type. I wanted to go back to the HPH comment as well. It would be good to know by habitat type as well. And so I think including that parameter would be helpful. So those are my two suggestions. And again, congratulations on working very seamlessly to produce a great cumulative impacts report by staff instead of contractor. Appreciate it.
Great points. Others with points, questions, thoughts? Commissioner Messner?
Thanks, and thank you very much for the work that's been done on this report. And these reports are no small effort. And so I have just one big broad question that I want to ask, and then I have some more specific questions. But one of the big kind of philosophical questions I wanted to ask was, from your perspective, how do you see the commissioners utilizing this report in our decision making?
Commissioner Messner, thank you for the question. That's a really good one. I'm not entirely sure how to answer it. Off the cuff, I would say that the accumulation of all of the reports, all of the annual reports that we put out, like let me back up. The 2024 report is a snapshot of the year 2024. We've got the 2021, 22, and 23 reports as well. And so in the 2024 report, we're looking both at that 1 year period, but also the cumulative time, since the report first came out in 2021 data. I would hope that the commissioners are finding the data that we're collecting through the Form 2B and then presenting in the report is useful to you in seeing sort of the big picture of impacts across Colorado, across different resource types. So impacts to air, impacts to water, impacts to people, impacts to wildlife. We're starting, I think, with this fourth annual report, we're starting to see some potentially solid trends in the data that I would imagine could be helpful to you in your decision-making process for CAPs and for OGDPs. Certainly, if there's something that, as Stephen mentioned, if there's something that we're not capturing that would be more helpful to you, either on that big picture scale, like, do you want us to do more sort of looking across the entirety of the data and providing a summary or trying to identify trends? If that's helpful, we're happy to do that. If you want us to drill down into more specific data on the Form 2B or add new fields to the Form 2B at a really, granular level, we're happy to do that as well. So I think the report, as it stands right now, and particularly the 2024 report, does both. It gives that big picture and the granular data. I'm not sure I'm answering your question very well.
No, you are. I'm trying to just understand your perspective as far as how we should utilize it as I imagine you were thinking about that as you were putting it together. And so I wanted to make sure that I understood that. So
Yeah, I think we're in alignment here. I guess one concern perhaps that I have is that if we do identify what we're calling a potential trend over 4 years, I want to remind everybody that in next year's report, that for 2025 data, it could be a completely different trend, right? It could whatever is happening in 2025 that's happened to date and that will happen in the second half of 2025. There was I think in the DI community section, distance to RBUs, there was a very clear trend, sort of moving like this. Well, what happens then if in the next year's report, the next number is down here? Does that obliterate the entire previous trend? Or is that a blip? And so I want to, I guess, caveat that the commission should consider the data that we have, consider that our interpretation of that data is an interpretation. It's not something that we're saying this is fact going forward. It will remain the same. So I think that there's some nuance in how we're looking at potential trends. And I do think that you as commissioners are very cognizant of that, and you do a really good job in OGDP hearings and in CAP hearings talking about what we think we see as a trend and how does this particular application fit or not fit into that. So I guess I would defer to you as commissioners on how you would like to use the data.
sure. No, that's fair. So a couple of specific questions. I'm a little curious just so that I better understand it on slide 27 talked about the utilization of the different 604B off ramps. And there was one that was associated with comprehensive area plans, preliminary siting approvals that was utilized. And I guess there's two different options in that 604B2. There's comprehensive development plans, and then there's comprehensive area plans with preliminary siting approval. And do you know offhand whether that was a CDP that created those numbers, or was it actually a comprehensive area plan with preliminary siting approval?
Are you referring to The comment that one of the locations used three different ones.
Well, no, the one number in this for 2024 that stands out to me is in figure 8I, and that's the 8 number there, which is higher than the other numbers, and it's the utilization of that 604B2. And I understand that there are comprehensive area plans that we approve that do have preliminary siting, but there's also comprehensive development plans that are allowed to utilize that off ramp. And I wasn't sure if these numbers were the comprehensive development plans or were actually comprehensive area plans with preliminary siting approval. And if you don't know that information, that's fine. I just didn't know if you knew that.
Thank you for the question, Commissioner. My recollection is that it is a mix of both CDP and CAP PSA locations. But you are correct. The 604B2 off ramp, though I summarized it as CAP with PSA, does include CDPs. And that is perhaps a topic that we could look into for next year's report, further breaking out which of those two forks of 604B2 are being used. So that's definitely something we can look into a little bit further, what the percentage is. Obviously
I don't know if that's
recognizing.
necessary or not. I actually was just more curious about this last year. So, but that's something that we can talk about further. But thanks for that. And then I did have a question on page 11 of your slides. It talked about the comparison of actual versus anticipated recycled produced water. And there was one in particular that stood out to me here, which was the West Slope OGDP 3 that estimated, over 2 million barrels of recycled produced water and ended up not recycling anything. That's pretty surprising because to me that's a pretty significant change. And do you know anything about that particular OGDP and what the situation there was? Because that certainly skews the numbers for the whole year, right?
It certainly does. Unfortunately, we did not have the spare capacity for the 2024 report to look into the why behind some of these numbers. That is definitely something that we are focusing on, as these are locations that are already drilled and completed. We have the opportunity to use this as a research project to further dive into the whys behind these misses going forward for next year's report. So that was certainly something that we noticed as well, and certainly is going to be a focus in the coming months as we do some of these longer term research projects to the end of calendar year 24 in preparation for next year's report.
Okay. Yeah, thanks for that, because that's one I would like to know about, mostly because, a proposed significant amount of reused and recycled produced water to zero, to me, is a significant change in an OGDP application. And so how that actually occurred is important information, I think, for me to know as a commissioner. The other one, and so to go into kind of broad suggestions or thoughts for future reports. I would agree with Commissioner Ackerman's comments, around reclamation and surface disturbance and habitat fragmentation. And I know this is a very complex topic, and we had long conversations about it during the cumulative impacts rulemaking. And so, to me, those continue to be very, I think, important topics as we look at cumulative impacts. And then I know that there's been, additional reports that have been developed on how compensatory mitigation funds are being utilized and the type of projects and the planning around that. For me, regular updates on that, understanding how that planning of that utilization of that compensatory mitigation is important for me to understand. I think it's good that you're thinking about coordinating with different entities around looking at whether we need to look at this from a basin standpoint, from a region standpoint. I would also throw out there that I think local governments are interested in understanding what's happened at the local government level. And so whether that's whether that they're trying to better understand cumulative impacts in their jurisdictions from a well density standpoint, from a new activity standpoint, those type of things from a local government jurisdiction standpoint, I think could be helpful as well, as we kind of look at different regions to look at for future cumulative impacts reports. And then to Sabrina's point, these are snapshots, these are annual snapshots. And so I wonder now that we're getting close to having 5 years, if there's a time frame when we look at actually a bigger block of time, right? So the whole 5 years or every 10 years or whatever that may be, but that we actually have kind of a deeper dive evaluation of trends over a broader amount of time. I know this happens annually in these cumulative impacts reports, but it may be like 5-year trends or 10-year trends, kind of a look back and really trying to better understand if there actually are trends once we start to get more years under our belts with the cumulative impacts report. And so I think those are my general thoughts on it right now. But again, really appreciate the work that's being done in it, and so thanks for that.
Other commissioners with thoughts, questions? Mr. Schwartz or Ms. Trask, will the slide deck be available to members of the public?
It should already be in the hearing portfolio for today's hearing.
Okay, we might make a place for folks to go see it that weren't aware of that it was being presented today. So like right now, the only way to find it is like you knew it was today, and you know how to get to that portfolio. It might be a good idea to have a link somewhere on our homepage.
We can definitely work to get that directly linked on our homepage, on our new improved homepage.
New improved homepage. Refresh your browsers. All right. Let's take 10 minutes before we get into our next docket. Let's go ahead and get that docket set up. It's the Noble Energy CAP and OGDP. Let's return at 11:10.
Good morning, everyone. This is Steven Smeltz, the hearing manager. We are still looking for Jared Martin. If he's in the participant list, could you please raise your hand so we can elevate him to the panel? Thank you.
Ryan, we can't hear you. This is Patricia Meinrich for Chevron. I know Ryan's having some technical difficulties. If you can hear me, Jared Martin is actually out today. His wife went into labor.
Thank you for that update. Congratulations.
Can you hear me now, Patricia?
Yes, we can hear you, Mr. McGee.
Thank you.
All right. We're going to take up dockets 2404-00093 and 00094. We're going to start by having a presentation from Mr. Kavanaugh from Weld County. Oh, actually, hold on just a second, Brett. Miss Weber, did you have something for the record regarding either application before I get into testimony?
Yes, Commissioner.
Go ahead.
Hello, my name is Kira Weber, and I'm the lead location assessment specialist for the Noble West Pony Cap and the West Pony 1 OGDP. I would like to make a clarifying statement in regards to the timing of the cap. The director's recommendation for the cap states that Noble is requesting the cap expiration to be 10 years and not 6 years by ECMC Rule 314. This is incorrect. Noble is requesting the cap have the same expiration date as the West Pony DSU, Order 5351352. If the cap is approved by the Commission today, both the cap and the 2 associated OGDPs within the cap will have an expiration date of July 14th, 2031. This does not change the determination of approval from the Director.
Great. Thank you very much. Appreciate the clarification. Mr. Kavanaugh, you're now recognized.
Thank you, and appreciate that. Well, good morning, commissioners, and thank you for the opportunity to speak for a couple of minutes about the Weld County regulatory process and some of the important factors that play into Weld County's review of both Noble's West Pony cap and the WP1 OGDP facility today. Comments were submitted to ECMC for the cap application, as well as 6 locations making up the WP1 OGDP. They're included in the director's recommendations. I will speak first to some details of the West Pony cap, CDP, Comprehensive Development Plan under Weld County Code. On June 27th, 2024, Weld County held a pre-application meeting for the West Pony CDP. Attendees included Weld County staff.
Mr. Kavanaugh, I don't know if it's just me, but I can't hear you anymore.
Can you hear me now?
Yeah.
Okay.
You might
Where did I drop off?
roll back a minute or so.
Okay, sorry. So here we go. I'll first speak to some details to the West Pony cap, or the CDP, Comprehensive Development Plan under Weld County Code. On June 27th, 2024, Weld County held a pre-application meeting for the West Pony CDP. Attendees included Weld County staff, Noble staff, ECMC, CPW, CDPHE. On October 17th, 2024, Noble submitted the West Pony CDP application to Weld County, consisting of 8 individual oil and gas locations. Weld County did not receive any public comments or applications for intervention. On the CDP application, the 1041 Wogler hearing for the West Pony CDP was held on January 23rd, 2025, and was also approved by the Weld County's hearing officer. The final order was recorded with Weld County Clerk and Recorder on January 31st, 2025, and published in the Greeley Tribune on February 5th, 2025, which creates a vested property right for each of the 8 individual oil and gas locations. Once the overall CDP and siting of the specific locations has been approved through Weld County, closer to the time of construction, the operator will submit the site-specific 1041 Wogley information detailing elements specific to the individual locations. Construction of the oil and gas location authorized by the CDP shall not commence until OJED staff has issued a determination that, based on the site-specific information submitted, the proposed oil and gas location and site-specific BMPs are consistent with the improved information provided in the CDP application and compliant with the requirements of Weld County Code. Site-specific COAs may be included with the OJED determination when necessitated. At least 60 days prior to construction of any location, Noble will submit site-specific 1041 Wogley information detailing elements of specific to the location. Today, you have also had before you the WP1 OGDP consisting of 6 individual oil and gas locations. At this time, Noble has submitted the site-specific 1041 Wogley information to Weld County for determination on 3 of those locations, being the GV31-15 multi, the LE02-04 multi, and the LE12-07 pad. These 3 locations have completed the Weld County process and have been permitted by administrative approval. Pending recording of the approved permit, notice will be published in the Greeley Tribune. The remaining 3 sites, GV25-16 pad, the LB30-08 pad, and the LB19-09 multi, making up the WP1 OGDP, have not yet been submitted to Weld County for review. As long as the site-specific 1041 WOGLA does not introduce any significant changes to a location, such as moving the location or expanding the surface disturbance of the individual locations that was approved under the CDP, the site-specific details will be approved through the administrative process. While Weld County has no concerns with the pending ECMC permit and would fully support approval, the Weld County reserves the right to review the site-specific details for determination of compliance with development standards and the Weld County Code at the time of site-specific submittals. I appreciate your time today.
All right. Questions for Mr. Kavanaugh? All right, I'm not seeing any questions. Again, we always appreciate your bringing Weld County's perspective to the permitting decisions that we're trying to make here. So thank you very much.
Thank you.
All right, Mr. McGee, do you want to elevate or have your witnesses all visualize themselves, and then we'll get them sworn in?
Absolutely. Can the team please visualize? I think we have everyone.
All right. Thank you, Mr. McKee. I'm Assistant Attorney General Kyle Davenport. I will swear the witnesses in. I'm just going to go in the order that I see you appear on my screen, and I'll ask you each in turn to raise your hand, state your name, and swear to tell the truth. We will start with Patricia Minrick, please.
Patricia Meinrich, I swear to tell the truth.
Thank you. I apologize for mispronunciations. Mr. Keller.
Michael Keller, I swear to tell the truth.
Thank you, Mr. Gruber.
John Gruber, I swear to tell the truth.
Mr. Ball.
Tony Ball, I swear to tell the truth.
Mr. Days.
Phil Dice, I swear to tell the truth.
Ms. Gramadsky.
Laura Gramadsky, I swear to tell the truth.
Miss Vaseva. We can't hear you. Still not. We'll give you a second, and Mr. Barnes, please go ahead.
Tyler Barnes, I swear to tell the truth.
Thank you.
I'm gonna try one more time. Can you hear me?
Yes, now we can.
Awesome. Irina Vaseva, I swear to tell the truth.
Thank you. Mr. McKee, is that everyone?
I believe so.
Okay, thank you.
All right, Mr. McKee, the video is yours.
All right, Laura, can you go ahead and start the screen share, please? All right. Well, good morning, commissioners, ECMC staff, and members of the public. My name is Ryan McKee, shareholder with Beatty & Wozniak, and with my colleague Laura Aronson, we represent Noble Energy in docket number 240400093, which is an application for approval of the West Pony Comprehensive Area Plan, and docket number 240400094, which is an application for the approval of the West Pony 1 Oil and Gas Development Plan that was submitted simultaneously with the West Pony CAP. The West Pony CAP encompasses the West Pony 1 OGDP because the lands, receptors, BMPs, and other relevant factors associated with both the West Pony CAP and the West Pony 1 OGDP contain significant overlap. In consultation with staff, Noble will present these two applications simultaneously this morning. Noble's presentation will first cover the West Pony CAP and then the West Pony 1 OGDP, and will request approval by the Commission in the same order following the presentation. Noble is excited to be able to jointly present the West Pony CAP and the West Pony 1 OGDP to you this morning. This represents over 5 years of planning by Noble and engagement with numerous stakeholders, including ECMC, CPW, and CDPHE. This process started with the West Pony State Unit and has now culminated in the simultaneous presentation of both the CAP and the first associated oil and gas development plan that covers nearly 80% of the CAP lands and requests final, not conceptual approval of 6 of the 8 proposed oil and gas locations planned for the CAP. Joining me today to present are Patricia Meinrich, Tony Ball, and Michael Keller from Noble. And we will also have a panel of subject matter experts to answer your questions following today's presentation. Noble's presentation will first cover the West Pony Cap, and we will address Noble's community outreach throughout the CAP process, the continued implementation of Noble's comprehensive wildlife plan in the CAP lands, and discuss engagement and approvals Noble has sought with the relevant local government, Weld County. Next, Noble will present the West Pony 1 OGDP. Noble will address the siting of the 6 proposed locations, as well as the alternative location analysis it conducted as part of its siting process. Noble will then discuss its engagement with CPW regarding the wildlife receptors within the West Pony 1 OGDP and its efforts to minimize any potential impacts to wildlife. Finally, Noble will discuss certain best management practices, advanced facility and infrastructure design, and other measures that it will employ to protect and minimize impacts to public health, safety, welfare, the environment, and wildlife resources. Next slide. As I mentioned earlier, the West Pony Cap represents the culmination of many years of Noble's close work with staff and consulting agencies for the thoughtful development of this project. On July 14th, 2021, in order number 535-1352, the Commission approved the West Pony State Unit and operating agreements pursuant to Colorado statute for the unitized development of approximately 17,400 acres for a 10-year term in accordance with the unit agreement. The unit agreement through order number 535-1378 was declared effective on April 6, 2022, following the approval of the unit agreement by at least 80% of both the cost-bearing and non-cost-bearing parties to the agreement. Paragraph 13 of the unit order required the approval of a cap before Noble could commence operations pursuant to the unit agreement and unit operating agreements. In compliance with this term, in April of 2024, Noble submitted the West Pony Cap. The cap covers not only the West Pony State Unit, but also, as a result of Noble's landscape level planning and continued consolidation efforts, a 3,200-acre DSU, the cap expansion area. Next slide. As encouraged by ECMC rules, our presentation reflects Noble's use of landscape level planning and thoughtful development. Noble now seeks approval of the approximately 20,749-acre West Pony Cap. Noble requests that the West Pony Cap be approved for a term to run concurrently with the initial term of the West Pony State Unit, expiring on July 14th, 2031, being a term of just over 6 years. The West Pony Cap complies with all procedural and substantive ECMC rule requirements, has been properly noticed for hearing, and recommended for approval by the Director. No comments or petitions against approval of this application have been received. Additionally, as you just heard, the West Pony Cap has been reviewed and approved by Weld County through the WOGLA CDP process, and Weld County supports your approval of this application. I will now hand the presentation over to Patricia Meinrich and the Noble team to provide you with further details of the proposed West Pony Cap.
Thank you, Ryan, and thank you, Commissioners, for your time. Let us start with an overview of the West Pony Cap. The West Pony Cap will develop 20,749.63 acres, including the 17,479.96 acres in the underlying West Pony State Unit, equating to approximately 32 square miles of mineral resources. Up to 181 new horizontal wells are proposed in the West Pony Cap, developing the minerals from a total of 8 locations, 6 in the West Pony 1 OGDP and 2 in the West Pony 2 OGDP, which will be submitted at a later date. There are 0 RBUs within 2,000 feet of the proposed locations. The West Pony Cap is largely within high priority habitat for pronghorn and mule deer. Noble has had multiple consultations with CPW about mitigations and operational timing that is protective of wildlife and habitats. The West Pony Cap is located within Weld County and is part of our larger comprehensive wildlife plan efforts to implement additional mitigation measures for the improvement of wildlife and habitat. Noble is planning a test or science well in the West Pony Cap to help define the resistivity of this largely undeveloped area. Consolidation is a central focus of Noble's planning. During the 5 years that we have spent working on the West Pony State Unit and CAP, we have examined our plans for development, looking for opportunities to improve designs, employ advances in technology, and test new feasibilities to help reduce our footprint. Throughout planning the West Pony Cap, up to 19 locations, eventually reduced to 9, were originally envisioned to develop the 17,479.96 acres of the West Pony State Unit. Following a lengthy planning process, locations were eliminated, consolidated, relocated, and combined using multis, which are combined well pads and production facilities. The West Pony Cap will be developed using 8 locations, 6 of which are in the West Pony 1 or WP1 OGDP, utilizing 3 multis and 3 standalone well pads. The red X's on the map represent the locations that have been eliminated over the planning process. When planning the development of the West Pony Cap, we saw an opportunity to further consolidate development outside of the West Pony State Unit. The West Pony Cap adds the West Pony Extension area in sections 20 through 22 and 28 through 29 of Township 9 North, Range 60 West. To accommodate this addition, Noble shifted the 2 well pads and 1 multi to the northeast extent of the West Pony State Unit to allow development in both directions. The dashed arrows on the map indicate how locations were shifted to accommodate the cap expansion area, allow for consolidation into multis, and our efforts to try to avoid high priority habitat. The timeline shown here highlights some of the key milestones along the West Pony journey. Planning the West Pony project started in February of 2020 with the West Pony State Unit approval in July 2021. Upon obtaining the requisite 80% approval from cost-bearing and 80% approval from non-cost-bearing parties, the ECMC declared the West Pony State Unit effective in April of 2022, dating back to July of 2021. The period between April of 2022 and April of 2024 was devoted to planning the overlying West Pony Cap. The first West Pony Community Outreach meeting was held on November 2nd, 2023, with the second community outreach meeting held on April 30th, 2025. The West Pony Cap and the WP1 OGDP were submitted together in April 2024. Multiple rounds of consultations with CPW were conducted from March 2024 through April of 2025. Both the West Pony Cap and the WP1 OGDP achieved completeness in March of 2025. Consultations with the CDPHE for the West Pony Cap and the WP1 OGDP were held about 10 days apart in April and May of 2025. Both the West Pony Cap and the WP1 OGDP received the Director's recommendation on May 22, 2025. Throughout the 5 years of the West Pony State Unit, CAP, and OGDP planning process, Noble has continuously engaged in ongoing consultations with residents, agencies, and local government. As highlighted on the previous timeline slide, community outreach and engagement for the West Pony Cap lands have been ongoing for years. On the next slides, I will discuss some of the ways that we have engaged with the community, answered their questions or concerns, and how we plan to continue that outreach in the future. We have worked with residents over the years to establish open lines of communication about our planned development. Our efforts are ongoing, and we do not stop today. Noble plans to continue to engage with our stakeholders through the following: maintaining a 24/7 non-emergency community line, ongoing updates on our West Pony website, an activity notice prior to each phase of operations, and additional community meetings as requested by residents, local government, or fire departments. Throughout our engagement, we have tracked and managed the communication threads with stakeholders that primarily focus on traffic, schedule, proximity of locations, noise, and light. As mentioned earlier, Noble has held 2 community outreach meetings at the Briggsdale School. Although there are no RBUs within 2,000 feet of any of the West Pony Cap proposed locations, everyone within the boundaries of the West Pony Cap was invited to attend each session. At the first meeting held on November 2nd, 2023, approximately 20 people attended. At the second meeting held on April 30th, 2025, approximately 9 people attended. The meetings had similar setups with approximately 20 subject matter experts stationed around the room, allowing for an open dialogue with residents. Information included poster board visual aids, computer-based mapping tools, and demonstrations from vendors such as Ascent and Project Canary. Spanish translation was also available. Events received positive feedback from residents. Let us now move on to the topic of wildlife as it relates to the West Pony Cap. Although the West Pony Cap avoids RBUs within 2,000 feet, the West Pony Cap is predominantly located in high priority habitat for pronghorn and mule deer, and there is not an opportunity to avoid these HPH areas. Originally, our planned locations highlighted by the green boxes on the map were located further south in the dark green shaded areas. In an attempt to avoid impacts and to minimize impacts to HPH, many of the planned locations were moved and consolidated. However, the HPH areas were later expanded in 2023, and Noble was not able to move the proposed locations outside of HPH. As presented in greater detail to this commission last year, in addition to the direct and indirect compensatory mitigation impact fees pursuant to the rules, we are also undertaking the Comprehensive Wildlife Plan that covers Weld County, including the West Pony Cap area. The Comprehensive Wildlife Plan seeks to go beyond the traditional mitigation hierarchy of avoid, minimize, and mitigate to add improve. To enable us to improve wildlife and habitat, we are applying a comprehensive strategy that looks at large-scale planning, utilizing science-based data to identify focus areas for mitigations and improvements, and to inform enhancement measures that will provide meaningful benefits to wildlife and habitat. The Comprehensive Wildlife Plan is comprised of a toolbox of programs ranging from a collaring program of pronghorn and mule deer to ascertain migration and habitat interaction data, supporting a public database of habitat indicators, focusing on native seed development, utilizing habitat restoration and enhancement practices, defragmenting habitat through a robust plugging and reclamation program, establishing offsets through conservation easements, BMPs tailored to pronghorn and mule deer, and leveraging external expertise. Since starting the Comprehensive Wildlife Plan, Chevron has collaborated with a half a dozen organizations, resulting in the collaring of more than 140 pronghorn and more than 60 mule deer since the winter of 2024. We funded an additive water enhancement project to an existing conservation easement, providing a new water well, tank, and solar-powered pump within the overall pronghorn and mule deer ranges and within 2.5 miles of HPH. Chevron is also in the process of donating the funding to preserve 131 acres of pronghorn winter concentration high priority habitat lands surrounded by the Pawnee National Grasslands to the Central Plains Experimental Range managed by the United States Department of Agricultural Research Service. Comprehensive Wildlife Plan is not a compensatory mitigation project pursuant to the rules. This project is voluntary and in addition to our direct and indirect impact mitigation fees. Additional milestones that have been achieved under the Comprehensive Wildlife Plan, specifically in relation to the Native Seed Program, include the collection of approximately 3,145,000 seeds during the fall of 2024 season, sowing and growing approximately 100,000 Colorado native plants for our live plant program. These seeds were collected through the Weld County area and are being grown in a nursery greenhouse to be transplanted back into the Weld County area at demonstration sites to increase the quality and quantity of native vegetation. The pictures shown here include images from our greenhouse, plants in the process of growing, seed cleaning and separation, and several species of plants that were collected and are growing in the greenhouse. In the winter of 2024 and 2025, animals were outfitted with GPS collars in Weld County to establish and maintain a steady sample size of 140 pronghorn and 60 mule deer as part of our collaring program. In a real-world application of the Comprehensive Wildlife Plan programs, the firestorm maps overlain on our West Pony Comprehensive Area Plan on the left represent utilization distributions depicting areas of use and probability of use within those areas for collared pronghorn beginning in the winter, spring, summer, and fall seasons of 2024 and 2025. The lighter yellow and orange colors represent areas with more GPS locations, indicating a higher relative use of collared animals, while the darker purple and black colors represent areas with fewer GPS locations and a lower relative use of collared animals. These maps do not represent resource selection by animals and reflect the spatial distribution of collared individuals. Final resource selection analysis at the conclusion of the study will provide representative relative probabilities of use from all collared animals based on landscape features, which will likely vary from the animal location maps depicted here. While the study is not complete, data has been collected for a little more than a year. As you can see throughout the season, the intensity of lighter colors varies, but the central area marked by the blue ring on the map corresponds to the 3 proposed locations cited in HPH and are within the darker purple areas. Although the data points from the coloring did not influence the timing of operations at the 3 proposed locations, as agreed to in consultation with CPW, this is an example of the potential for utilizing science-based data to inform future minimization and mitigation measures and focus areas for application. As typical of science-based study results are representative of the subjects in the study, therefore absence of evidence is not evidence of absence. At the conclusion of our study, we will develop a resource selection model which will predict the relative probability of animal occurrence based on important habitat features of the area. My colleague will speak more about wildlife in the WP1 OGDP section. For now, we will move on to the local government approval. Weld County is the relevant local government, and there are no proximate local governments. Noble has engaged in 2 Weld County pre-app meetings with representatives from ECMC, CDPHE, and CPW. On January 23, 2025, Weld County held a WOGLA CDP hearing for the West Pony CDP and approved the lands and locations associated with the West Pony CAP. I will now hand the presentation back to Ryan McGee to conclude the West Pony CAP and introduce the West Pony 1 OGDP or the WP1 OGDP.
Thank you, Patricia. As demonstrated by the West Pony CAP presentation, the West Pony CAP is a continuation of Noble's goal of doing more with less, proposing to develop approximately 20,749 acres with only 8 new oil and gas locations. The West Pony CAP includes all lands within the West Pony State Unit, as well as an approximately 3,200 acre proposed drilling and spacing unit in the eastern portion of the CAP. Noble's continued commitment to consolidation directly led to the inclusion of the proposed DSU to the West Pony CAP as originally contemplated, and if approved, will allow for an additional 3,200 acres of mineral recovery without any additional surface disturbance. In addition to consolidation, in an effort to improve regulatory efficiency and provide greater certainty to its proposed development under the West Pony CAP, Noble does not seek preliminary siting approval of oil and gas locations under Rule 314b5. Rather, with its contemporaneous West Pony 1 oil and gas development plan submittal, Noble seeks full oil and gas approval of 6 of the 8 oil and gas locations within the CAP pursuant to Rule 303 and Rule 304. After Noble has gained further insight into the geologic characteristics within the CAP through the initial development of the West Pony 1 OGDP, Noble will then take the gained knowledge and apply it to allow for the most efficient and protective development of the West Pony 2 OGDP. This concludes Noble's West Pony CAP presentation. Noble will now present the West Pony 1 OGDP. Following this presentation, Noble's panel of experts will be available to answer any questions on both the CAP and the OGDP that you may have. Now, after describing the landscape level planning and resulting consultation that Noble was able to achieve, or consolidation that Noble was able to achieve through the West Pony CAP process, Noble will now provide further detail regarding its first of 2 oil and gas development plans that will be utilized for the development of the West Pony CAP, the West Pony 1 OGDP. As part of its request today, Noble seeks approval of approximately 16,251 acre West Pony 1 OGDP. The West Pony 1 OGDP proposes to develop approximately 13,051 acres within the West Pony State Unit and the entirety of the proposed 3,200 acre DSU. Like the West Pony CAP, Noble requests that the West Pony 1 OGDP be approved for a term to run concurrently with the initial term of the West Pony State Unit, expiring on July 14th, 2031. Finally, to allow for the development of the proposed West Pony 1 OGDP, Noble requests the approval of the proposed 3,200 acre DSU. The West Pony 1 OGDP and the new proposed DSU comply with all procedural and substantive ECMC rule requirements, have been properly noticed for hearing, and recommended for approval by the director. No comments or petitions against approval of this application were received. Additionally, the West Pony 1 OGDP has been reviewed and approved by Weld County through its WOGLA CDP process, and Weld County supports your approval of this application. I will now once again hand the presentation over to Patricia Meinrich and the Noble team to provide you with further details regarding the West Pony 1 OGDP.
Thank you, Ryan. Now that we have outlined the West Pony CAP, let us look closer at the WP1 OGDP. The WP1 OGDP represents years of planning and continuous improvement as demonstrated through our consolidation efforts to deliver an OGDP that will develop 16,251.83 acres and 133 horizontal wells from a total of 6 locations, 3 well pads and 3 multi-pad production facility combos. The WP1 OGDP will feature the latest tankless facility design, as well as oil, gas, and water pipeline takeaway, which will eliminate truck hauling. As the WP1 OGDP is located within high priority habitat for pronghorn, Noble has had multiple consultations with CPW about mitigations and operational timing that is protective of wildlife and habitats. As with the West Pony CAP, the WP1 OGDP is located within Weld County and is part of our larger comprehensive wildlife plan. Within the WP1 OGDP, we plan 1 DSU in the West Pony CAP extension area covering approximately 3,200 acres. The rest of the WP1 OGDP is within the West Pony State Unit and will not require DSUs. Allocations will be made to drill blocks as set forth in the unit agreement. Noble owns and/or has secured the consent of more than 45% leasehold throughout the DSU and the remainder of the CAP. The schedule represented here shows the anticipated schedule when filing. Operations will not commence until approval of the CAP, associated WP1 OGDP application, and the relevant Form 2As. I will now turn the presentation over to my colleague Tony Ball to discuss siting and alternative location analysis.
Thank you, Patricia. Good morning, Commissioners. My name is Tony Ball, Land Representative at Chevron. I'd like to dive into the surface location highlights specific to the West Pony 1 OGDP. Next slide. On this slide, you'll see a high-level surface location highlights for the 6 proposed locations. These highlights include the following. Noble has obtained surface use agreements for all 6 locations. Through its review, Weld County indicated these locations to be its preferred and least potentially impactful to develop this OGDP and has granted approval of the WOGLA CDP for all 6 locations. There has been no land use changes to these locations since the approval of the CDP. All 6 locations are outside any designated DIC. No RBUs within 2,000 feet of all 6 surface locations. And the last highlight I'll note is that all 6 locations are located over 1 mile from any schools, childcare facilities, designated outdoor activity areas, as well as any public or surface water supply areas. 4 of the 6 locations are currently enrolled in the Conservation Reserve Program. During Noble's discussion with these landowners regarding the siting of the proposed locations within CRP lands, Noble spoke with the landowners about the impact of using CRP lands for oil and gas development and the required CRP removal process the surface owners will need to undertake with the Farm Service Agency. The surface owners understood and support that they will need to contact the FSA and make necessary repayments. As with all of Noble's surface locations, when conducting our site selection and ALA process, Noble considers the following. Consolidation of pads and/or facilities, evident in the extension lands included in this OGDP submittal, the site's proximity to building units, operational feasibility, which means does the location meet standards of our site-by-site risk assessment for development? Does the location require an additional pad and/or facility location to develop the target minerals? Next, potential impacts to known future land uses. Will this site have negative impacts of known future development if there are any pending development plans in the area? And if the site is being planned on lands that are intended for long-term farming operations, will the surface owner and/or their tenant be negatively impacted? Proximity to cultural features, environmental concerns, such as wildlife corridors, raptor or eagle's nests, prairie dogs, burrowing owls, wetlands, floodplains, designated surface water, and much, much more. The access to the location, surface owner negotiations, and finally, geology. Does the subsurface structure formations complement the surface location and allow for safe, effective, and efficient development of the target hydrocarbons? These are just some of many factors that Noble examines when selecting its proposed sites, as well as those sites it uses when conducting its alternative location analysis. Through our analysis, we evaluated 9 alternate locations for the 3 surface locations that triggered an ALA review. The yellow alternate locations shown on the map were eliminated once the evaluation deemed them to be not as protective as the proposed locations. And the green locations you see are the proposed West Pony 1 OGDP surface locations that we will review in the next few slides. The next 4 slides provide high-level siting requirements for the 6 locations within the West Pony 1 OGDP. As previously mentioned, all 6 pads in the West Pony 1 OGDP have 0 RBUs within 2,000 feet and do not impact any irrigated cropland. On this slide, you'll see information for the 3 locations: the LB 1909 multi, the LB 3008 pad, and the GV 2516 pad. The LB 1909 multi will process production from both the LB 3008 and GV 2016 pads. I've lumped these 3 locations onto one slide due to the following similarities. All 3 locations are outside any designated high priority habitat. All 3 do not require an alternative location analysis, as there are no receptors within 2,000 feet of working pad surface. And the centralized placement of the proposed locations on the eastern side of the West Pony unit boundary enables development of the CAP extension without any additional service development or impacts. We'll now look into the GV 3315 multi and the siting requirements surrounding it. This multi configuration allows for development and production into a co-located central production facility. The GV 3315 multi, along with the next 2 locations, the LE 0204 multi and the LE 1207 pad, are within HBH for pronghorn winter concentration. Our wildlife specialist, Michael Keller, will dive deeper into HBH timing stipulations for all 3 pads later in this presentation. Now we'll look at the LE 0204 multi and its siting requirements. The multi configuration allows for development and production to a co-located central production facility, as the LE 0204 multi will process production from both the LE 0204 pad and the LE 1207 pad that we'll look at in this next slide. The last location is, in fact, the LE 1207 pad. As I mentioned in the last slide, the production from this pad will be routed to the LE 0204 multi in an effort to consolidate the production to our centralized facilities. In addition to our consolidation efforts, Noble also undertakes an exhaustive alternative location analysis. Our surface land team evaluated numerous potential locations, and we eliminated sites that fell into one of the 4 designations shown on the slide: operational feasibility, proximity to RBUs, landowner preference, and wildlife. Locations are categorized as not operationally feasible if their geographical location creates the need for an additional pad or facility to develop the target minerals, which in this area would cause for additional unnecessary disturbance to receptors, such as HPH. We preferred an operational corridor approach that utilizes one consolidated production facility, so alternate locations that would cause a need for an additional pad or facility were quickly ruled out for lack of feasibility. Any alternate locations within 2,000 feet of an RBU were automatically eliminated, and locations in the landowner preference designation were not selected because the landowners were not interested in siting a pad or facility at the identified location for a variety of reasons. Lastly, a large amount of our alternates fell into the close proximity to established wetlands bucket, which lumped them into a wildlife designation. Next slide. On this slide, you'll see the zoomed in images of each location and their associated alternative locations. For the GV15 multi, we evaluated 4 alternates. All 4 fell into the operational feasibility designation, 3 of which were also within close proximity to established wetlands. During the time of siting, the location directly south of the preferred GV3315 multi was located in HPH for pronghorn winter concentration, and the preferred location was not. After new HPH boundaries were introduced by CBW, our preferred site was now also within HPH. Both locations are on the same surface owner, and after discussions with that owner, the decision was made to move forward with our preferred location. For the LEO 204 multi, we evaluated 4 alternates as well. Once again, 3 of them fell into the operational feasibility designation, and 2 of which were also within close proximity to established wetlands. One of these alternate locations was not selected due to the landowners not being interested in siting a pad at that location. That now brings us to the LEO 207. For this pad, we evaluated 2 alternates. Both locations brought RBUs within 2,000 feet of the pad. For that alone, these 2 alternates were eliminated. As you can see, the planning of the West Pony 1 OGDP has been extensive and thoughtful. We believe that the 6 proposed locations before you today allow for the greatest reduction and mitigation of impacts to all stakeholders, including wildlife, while also working with surface owner preference and operational feasibility. Our planning process has been done in conjunction with the community's preferences and concerns in mind, and we're proud of that collaborative effort that minimizes impacts to public health, safety, welfare, and the environment. With that, I'll hand it over to Michael Keller to discuss wildlife.
Thank you, Tony, and thank you to the commission. My name is Michael Keller. I'm an environmental specialist supporting Noble's Colorado Development Properties. The following slides are presented to summarize the overall wildlife situation and environmental protection commitments for the West Pony 1 OGDP application. This initial slide shows the extent of the West Pony 1 OGDP project area. As has been stated, 3 pads within pronghorn winter concentration area, high priority habitat, and 3 pads outside of the big game habitat. As Patricia testified earlier, and as Tony did as well, for the CAP, a significant consolidation effort has taken place for the project, with the focus in 2022 to keep all of the proposed pads outside of the pronghorn habitat. The habitat was subsequently realigned by Colorado Parks and Wildlife in 2023 and now covers the 3 pads shown here to the southwest. For the overall project, Noble commits to pipeline takeaway for oil, gas, and produced water, significantly reducing truck traffic and associated emissions. The GV 3315 and LE 0204 multipads will have tankless facility design with bulk and test separation, again, significantly reducing facility infrastructure and emissions. And Noble is committing to direct impact and indirect impact compensatory mitigation fees for the 3 pads inside the pronghorn high priority habitat. And we are voluntarily committing to pay the maximum amount of indirect fees regardless of the timing for development activities. Final post-completeness consultation with Colorado Parks and Wildlife and ECMC staff occurred in May of 2025. CPW provided final wildlife mitigation plan approval and confirmed that the pronghorn winter concentration area high priority habitat timing stipulations between January 1st and April 30th will be applicable to the OGDP well pads. And as always, Noble is extremely appreciative to CPW and ECMC staff for their consistent engagement and guidance throughout the OGDP application process. CPW agreed to allow timing relief at the GV 3315 and LEO 204 multipads. Both pads have limited disturbance outside of the pad extent, mostly as short access roads to established county roads, and no off-site flow line construction is required as the facility is immediately adjacent to the wells. Also, a full aquatic resource inventory analysis was conducted for each pad by a professional wetland scientist. Colorado Parks and Wildlife issued a 1202A3 waiver for the GV 2516 pad. That was the lone application that was needed. This slide provides a summary of the extensive consultation with Colorado Parks and Wildlife, beginning with the Weld County pre-app meeting in October of 2023, continuing with the CPW and ECMC field on-site of the West Pony 1 pad locations in March of 2024, and then culminating with the Colorado Parks and Wildlife formal approval of the wildlife mitigation plans and calculated direct and indirect compensatory mitigation fees in 2025. The lower table of this slide outlines the project commitments and Colorado Parks and Wildlife's relief granted for the LEO 204 and GV 3315 multipads. To summarize for the Commission, Noble is committing to schedule 7 of the 9 phases. This includes construction, drilling, and completion phases for 3 pads, representing 77% of the proposed activity outside of the pronghorn protective timing stipulation. So at this time and per our current development schedule, Noble will construct all pads located in high priority habitat. This includes sound wall insulation outside of pronghorn winter concentration area timing stipulations. Noble will commit to performing drilling and completion activities at the LE 1207 well pad outside of the pronghorn winter concentration timing stipulations. Per Colorado Parks and Wildlife concurrence, Noble will be allowed to drill the LEO 204 wells inside of the protective timing stipulations while being mitigated with sound wall protection, and then we will complete the wells outside of the stipulations. Similarly, and per Colorado Parks and Wildlife concurrence, Noble will drill the GV 3315 wells inside of the protective timing stipulations, again under sound wall mitigation, and then we'll complete the wells outside of the stipulation. This final slide just provides a quick overall summary of committed wildlife BMPs for the project, including the use of Colorado Parks and Wildlife recommended seed mix for pronghorn, the use of pronghorn friendly fencing, again, utilization of sound wall protection for pre-production activities, use of bird deterrent devices, and remote monitoring automated alarming. Thank you. I'll hand the presentation back over to Patricia for an overview of additional committed BMPs for the project.
Thank you, Mike. To complement our minimization and mitigation efforts for wildlife, the WP1 OGDP also includes efforts to minimize and mitigate impacts to air quality, odor, light, noise, water, and land. On April 22, 2025 and May 1, 2025, Noble met with CDPHE and ECMC for the West Pony CAP and the WP1 OGDP CDPHE consultations, respectively. The West Pony CAP is not located within a disproportionately impacted community, and none of the proposed WP1 OGDP locations are sited within a disproportionately impacted community. Each of the proposed locations have an Enviro Screen score of 26.7. Noble agreed to 31 BMPs from the CDPHE. Design features of the WP1 OGDP, as with the larger West Pony CAP, incorporate a number of best management practices, or BMPs, to protect the public health, safety, welfare, environment, and wildlife. Many of the BMPs related to air quality are also part of the commitments made through the CDPHE consultation. To avoid and minimize impacts related to odor and air quality for the WP1 OGDP, we intend to use the electric line power for the drilling rig, or Tier 4 diesel if sufficient grid power is unavailable, and to utilize electric equipment at the facility. Originally, we were only able to commit to Tier 2 diesel drill rig, but through continued work with our vendors, we are able to commit to the deployment of a Tier 4 diesel drill rig if grid power is not sufficiently available for the use of an electric drill rig. We will use pipeline infrastructure for oil, gas, and water takeaway, thereby eliminating truck hauling. The WP1 OGDP will also feature a tankless facility design, Type 3 drilling fluid, and an advanced flowback design resulting in zero uncontrolled emissions. Noble has worked with Morgan County Rural Electric Association for over 2 years to supply grid power to the proposed operations and is continuing to work with the utility. In 2024, as part of the commitment to electrify our planned operations, Noble paid for the electric meters to be installed, invested in breaker upgrades, and committed to feeder upgrades for the infrastructure needed to allow for grid power. The utility is currently reviewing its ability to provide the capacity needed for electrification and has indicated to Noble that a proposal covering the specific capacity available to Noble for the West Pony 1 OGDP will be provided once that review is complete. Noble has and will continue to use best efforts to work with the utility to determine what electrification levels are possible based on the capacity levels the utility is able to provide. Additionally, Noble will continue to pursue potential innovations and alternatives to provide for the electrification of its operations. All locations will include a continuous air monitoring program that is in accordance with the approved air quality monitoring plan from CDPHE. The images on the right show an example of view sensor data collected by the continuous air monitor. To avoid and minimize impacts from light and noise, well pad locations will feature sound walls during pre-production activities. Lighting will be directed inward and downward. No permanent lighting on well pads, and sound impact analysis will be conducted to produce sound models. The picture to the right demonstrates how lighting is contained within the sound walls. The images on the next couple of slides provide a visual representation of the differences in noise levels between an unmitigated site and a mitigated site. The image on the left models a location without mitigations during drilling operations. The image on the right models a location that utilizes sound walls to mitigate noise impacts. As you can see from the color coding, noise levels just outside of a mitigated location with sound walls is comparable to a conversation. Similar to the previous slide, the images here represent an unmitigated location and a sound wall mitigated location during fracturing. The image on the right models the mitigated quiet fracturing operations that are once again comparable to a conversation. To avoid and minimize impacts to water and land, the WP1 OGDP will incorporate a tankless facility, SCADA equipment for a rapid shutdown, segregated and stockpiled topsoil retained for reseeding and erosion and sedimentation controls. The image on the right depicts a modern tankless facility layout with bulk and test separation. This current generation facility design highlights reduced equipment, emissions, and footprint from previous design generations. To summarize our efforts to avoid impacts from the WP1 OGDP, we are outside of 2,000 feet from RBUs, schools, childcare, and HOBUs. We are outside of disproportionately impacted communities. We will eliminate emission sources due to our tankless design and pipeline takeaway. Our minimization efforts include the installation of sound walls on drill pads for drilling and completion activities, using an electrified drill rig on grid power with Tier 4 diesel if grid power is not available, utilizing electric equipment at the centralized production facility to minimize combustion sources, utilizing a quiet frac fleet and Group 3 drilling mud, conducting regular inspections and monitoring using switches, timers, and motion sensors, and having remote shut-in capabilities. Our mitigation efforts, we will plug 11 legacy well and facility locations, and we will pay the applicable direct and indirect wildlife mitigation fees. The WP1 OGDP footprint demonstrates Noble's efforts to minimize impacts through consolidation and reducing the number of locations necessary to recover the target minerals. Initial post-interim reclamation calculations overestimated our long-term surface disturbance impacts and did not account for the reclamation and reseeding of stormwater ponds, channels, and topsoil stockpiles. Following guidance from the staff to include these reclaimed areas, Noble's impact will be less than originally anticipated. Although Noble's impact is less, Noble is not requesting that the impact fees committed to with CPW be redetermined. For purposes of this OGDP application, Noble has proceeded with the original calculations and any compensatory fees calculated therein. However, following interim reclamation, the recalculated footprint of the proposed locations will be a little more than 57 acres out of the 16,251 plus acre development. Noble will also plug approximately 11 locations for an estimated 16.5 acres, reclaimed further, reducing the development footprint for a net disturbance of 40.9 acres after interim reclamation. The colored boxes on the right represent the relative size of the WP1 OGDP proposed locations shaded in green in relation to the larger light blue shaded WP1 OGDP and the larger still dark blue shaded West Pony Cap. Thank you for your time. I will now turn the presentation back to Ryan McGee of Beatty & Wozniak for the conclusion and requested relief.
Thank you, Patricia. Both the West Pony Cap and the West Pony 1 OGDP demonstrate how Noble has utilized landscape level planning to allow for both an innovative and efficient development planning process, helping to ensure Noble's planned developments are the least impactful and continue its ethos of doing more with less. Next slide, please. The landscape level planning encouraged by the West Pony CAP process and further refined through the West Pony 1 OGDP process directly led to Noble's inclusion of the proposed DSU into the West Pony CAP, which originally contemplated development of only the West Pony State Unit. Through this consolidation effort, if approved, Noble will be able to achieve an additional 3,200 acres of mineral development without any additional surface disturbance. The West Pony 1 OGDP at 16,251 acres is one of the largest mineral development areas under any OGDP, but with fewer surface impacts. The 6 surface locations planned for the West Pony 1 OGDP will allow for the development of up to 133 new horizontal wells from a surface footprint representing only 0.35% of the entirety of the West Pony 1 OGDP mineral development area and just 0.28% of the West Pony CAP mineral development area. Just as importantly, there are 0 RBUs within 2,000 feet of the 6 proposed locations within the West Pony 1 OGDP. 3 of the 6 oil and gas locations proposed within the West Pony 1 OGDP are within high priority habitat, which could not be avoided given the pervasive nature of HPH in the West Pony 1 OGDP and the West Pony CAP as a whole. In addition to the mitigations, Noble is proposing a number of minimization measures to protect wildlife. Many of the proposed BMPs are designed specifically with pronghorn in mind. Additionally, Noble will comply with the winter timing stipulations for all but 2 of the 9 development phases associated with the 3 proposed locations that are located within HPH. And this is done at the request and recommendation of CPW. Noble is further committed to several wildlife improvement efforts that you've heard about today, including their native seed program and pronghorn collaring programs. This marks the final slide in our presentation today, which is a summary of the requested relief for both the CAP and the OGDP. Noble procedurally first seeks approval of the approximately 20,749 acre West Pony Comprehensive Area Plan to be developed by 2 OGDPs covering a total of 8 oil and gas locations. Noble next seeks approval of the approximately 16,251 acre West Pony 1 OGDP and the associated 3,200 acre DSU. The West Pony 1 OGDP provides for the development from 6 proposed oil and gas locations, providing for up to 133 new horizontal wells, developing the Niobrara, Fort Hays, Codell, and Carlisle formations. Both the CAP and the West Pony 1 OGDP include requests that the final CAP, OGDP, and associated Form 2As be termed consistent with the West Pony State Unit, which would provide that the CAP, OGDP, and Form 2As expire on July 14th, 2031. We would like to thank staff for its thoughtful technical review of this project and the director's recommendation for approval. We also would like to thank Weld County for its comments at the outset of today's hearing and for Weld County's support for the approval of this project. Finally, we'd like to thank you, commissioners, for your attention during today's admittedly longer presentation. And this concludes our presentation, and the panel is now available for your questions.
All right. Thanks for the presentation. Commissioners, it's 12:10. I'm sort of inclined to take a quick lunch break before we come back and get into Q&A. If everybody's good with that, let's return at, let's say 12:50. That's 40 minutes. And then we'll come back for questions then, Mr. McGee.
That works for us.
All right, we are back. This is the Energy and Carbon Management Commission on June 25th at 1 p.m., taking up dockets 0093 and 0094. Mr. McGee, if you could raise or visualize your witnesses, we'll turn to Q&A.
Hey, could everybody please visualize from
All right, I see a number of witnesses. I think what we're going to do is, let me just sort of chart this out. We've got 2 applications before us, the comprehensive area plan as well as the WP1 OGDP. And I think we'll do Q&A on kind of both matters. I think it's going to be hard to kind of separate them out. And then after we're done, we'll take up the deliberation on comprehensive area plan first, and then deliberation on the OGDP. Does that sound fair, Mr. McGee?
That sounds fine with us. I agree. They're relatively consistent and hard to separate. So
yeah. All right. Who has questions? Commissioner Messner.
Thanks. Thanks for the presentation and the application. Lots of good stuff in the application, and a lot of work obviously went into it. So thank you. I did have one question though regarding the reuse and recycling of produced water. The CDPHE recommended BMPs that I think you've agreed to did include some requirements for reuse and recycle of produced water, but I didn't hear you talk about it in your presentation. And so I wonder if you could talk a little bit about whether there is an intent to have some reuse and recycling of produced water, and if so, what does that look like?
Thank you for the question, Commissioner. My name's Tyler Barnes. Yeah, our intent in West Pony is to perform recycling operations using on-site supplemented water, and then bringing in third-party produced water also. At this point in time, our mobile recycle units are supposed to hit the ground second quarter next year. So our intent would be to have those units available for this development.
Okay. And do you have a goal for that, or what does that look like? And I'm asking this mostly because I'm curious about what you're proposing here, because it seems like a great opportunity.
A goal as far as our recycle plans?
Yeah.
Yeah. So our goal right now is to get mobile recycle units on the ground, recycling water second quarter of 2026, and we plan on using those in all of the areas that we have under development, where we have access to the produced water, and this development is one of those.
And will you be using some produced water from some previously drilled wells in the West Pony OGDP to do other ones, or what does that look like?
Yep. We would bring in. We would use third-party water up in that area. There's taproot, right, gathering lines that we would tap into, and we'd use those water. You would use that water and recycle that and support our frac operations.
Okay. Thanks. That's the only question I have.
Yes, sir. Thank you.
Other commissioners with questions? Commissioner Ackerman?
Thanks, Mr. Chair, and thank you for the presentation. I agree with Commissioner Messner. A lot of great work here and extensive work, and I especially appreciate your extensive consultation and work with CPW on this project. As you noted, you were able to keep 3 of the 6 locations outside of HPH, even with the change in HPH mapping. And I do recognize that those map boundaries have changed, and it certainly appears to me that you've worked with CPW to pivot with those changes. And I also appreciate your work to keep the majority of the intensive development outside of the timing limitations period, and your detailed explanation of both in written format today and your testimony as to the lengths that you've gone to try to do that. I just have one question associated with the 3-phase takeaway, and appreciate once again, this is yet another great best management practice that's going to be very beneficial for wildlife as well. And my understanding is certainly there will be flow lines that take the fluids to the on-site or on-cap processing facilities. Can you just take a second and talk to me a little bit about what happens from there? Where do they go from the processing facilities, and how do they get off-site?
I can take that question. Thanks, Commissioner. So yeah, you're indeed correct. The flow lines from our pad only locations will be routed to our multi production facilities. From there, oil, gas, and produced water will be pipeline takeaway, to our central gathering facilities in the basin.
Thank you. I appreciate that clarification. And lots of times, we see things that are three-phase takeaway from the site just for a short distance to processing facilities. And we appreciate the additional work that's going into taking this into a true pipeline type situation and moving things off site all the way in pipelines. That's all I had for the OGDP, but I do have a couple of questions on the CAP as well. And I wanted to say that I appreciate Chevron's continuing wildlife work, and thank you for the update on that. I appreciate that whenever we can get one, so thank you, Ms. Meinerich. And I, as one commissioner, certainly take this into account when I'm reviewing Chevron's applications. But even with the voluntary work done through that, I do continue to consider ways to develop that will have minimal impact on wildlife on a project-by-project basis. And I have two primary points of concern with the CAP itself. The first one is the location of the locations in OGDP2, and my understanding is that we're looking for conceptual approval, not preliminary approval on those locations. That's LE 05-02 and LE 06-07. And then I also have a concern about the soft commitment to electrify drilling. In accordance with the CPW comments, those two pads in OGDP2, they express concern how far both locations are from existing roads, and stated that it's one of the more remote Weld County sites that site visits that they've conducted in more than 8 years. Those sites really are smack dab in the middle of unfragmented wildlife habitat, as I can see so far. With LE 06-07 being really far into an unfragmented 9 square mile parcel that's at least a mile from the nearest county road in all 4 cardinal directions. And so, as I understand it, those are yet to come in a second OGDP. And we saw lots of notes in this about locations, and it was mentioned today being dictated by landowner preference, and I certainly understand that. I did see one note that in this specific case, it was specifically to allow for development of road into the unfragmented habitat was one of the primary drivers. So you can help me if I'm wrong there, but that causes me concern. I'm not in favor. I believe that the CAP is well done. OGDP 1 is great, and I'm in favor of it moving forward. I'm not in favor of granting conceptual approval to these 2 locations in OGDP 2. Due to the same concerns that are raised by CPW. And I note that CPW asks and expects Noble to continue working with them on ways to avoid, minimize, and mitigate. I'm not sure that if that's just a one-sided statement from CPW, so I'd like some clarification on that. And I mean, the entire area, as you noted, is predominantly located in HPH, and in order to address impacts when locations can't be moved outside of HPH, which you have done to the greatest extent possible, CPW then employs minimization measures that include co-locating facilities or locating them close to existing disturbance. And certainly they've expressed historic concerns and continue to express them with locating them in the middle of significantly unfragmented habitat within HPH. And so I just hope that you would address those couple of points that I raised, but also the opportunities to continue to work with CPW with regard to moving these locations into, closer to existing disturbance and in a way that is more in accordance with how CPW generally recommends that we avoid, minimize, and mitigate these types of locations.
Thank you, Commissioner Ackerman. I appreciate the question. So the locations in WP2 will be forthcoming at a later date. We have yet to settle on what that will be. And we are working with CPW on consultations with those locations due to where the high priority habitat boundaries are in that area. There is no option to move them outside of HPH if we were to use even alternative locations. And my colleague Tony Ball can speak to that as well.
Yeah, thanks, Commissioner. When the service line team was was planning the WP2 locations. The road comment that you had really revolves around county road right of way in that area. A lot of the county road right of way has been vacated or not been built out, as you mentioned, in kind of a 9-section undisturbed area there. And so in order to get access to these locations and to find the best, most optimal pad location for Noble and for the landowners in the area, we do plan to utilize a county road right of way. And so that's more of the access standpoint. The pad locations, to Patricia's point, they are in HPH. We did avoid the mule deer HPH right there along Crow Creek, and so we've tried to shift these pads to where we can, and have run into roadblocks with other landowners not wanting to site pads in the area. So I do hear your concerns. We're always evaluating these areas, and if there's anything we could do, to further consolidate, I can tell you that we're going to look at improving what we can and where we can, if possible.
Thanks. I appreciate those responses. And so to be clear, from your responses, I should take that you're not looking for conceptual location approval of those 2 sites at this point. But the intent is to continue to work with CPW and within your own organization to improve the locations as much as possible before they come back in OGDP2. Am I misstating that?
Thank you for the question, Commissioner Ackerman. No, I believe that is an accurate statement. What the CAP is saying is that we will use 2 locations to develop OGDP2, but yet we're still evaluating where those will be. Part of it's the geologic concerns, and part of it is the wildlife concerns you mentioned. So the CAP is indicating that 8 locations in total will be used to develop the CAP, but the 2 locations that will be proposed in OGDP2 are yet to be confirmed, and we're not seeking approval of those today.
Understand that. Thank you. I appreciate that clarification, and that certainly helps me with regard to the CAP decision itself. And might go without saying, but I'm going to say it anyway, that I certainly would expect, based on certainly your history and what you try to do and all your other developments, but also in CPW's wishes, that you'll continue to work with CPW and find some ability to avoid, minimize, and mitigate those ones, as they're currently at least somewhat concerning. Thank you. My next question and final question really was with regard to electrification of drill rigs. And, the intent of a CAP from ECMC perspective is to ensure the implementation of planned infrastructure in ways that offer benefits over an OGDP by OGDP approach. And so I have a bit of a concern about the soft language that's allowing for the use of non-electric drilling rigs. And that really is just like the language we often see in OGDPs, that, hey, we're going to do our best, we're making progress, we're working, but we're going to move forward one way or the other. And while there is trust certainly on my part, it does create an approval type situation that would allow just the complete moving forward without the electrification of drilling rigs when, that's something that we may have assumed was going to move forward. And so I kind of look at this as, from the flip side, one of the benefits of the operator to the operator of a CAP is the exclusive right to develop within the CAP lands. And to me, this is kind of the same as ECMC, including language stating that it'll strive towards the operator having exclusive right to develop, but that no more than 2 other operators will be permitted, right? That's that soft language that would cause a lot of concern, I think, to the operator. And so that open door causes me some concern. So can you talk a little bit more? You did talk about some of your progress there, and you've made considerable progress, and I don't want to discount that. Can you talk more about probabilities? Can you talk about why it's not possible to wait until you can commit to electric drilling to move forward on this CAP? Thanks.
Yes, thank you, Commissioner. So as we've stated, we have been working with the utility for over 2 years, and we are continuing to work with them. Electrification is never guaranteed. Even when we've had complete assurances from utilities that capacity would be available, there have been issues with utilities being able to deliver. This is a challenge throughout the basin, and our approach is to work routinely with the providers on that ongoing capacity. We're committed to that here, and we will continue to work with the utility to expand and implement electric power when it becomes available And to that, we've been able to upgrade our original commitment of a tier 2 engine to a tier 4 rig if that power is not available, to further minimize any impacts. And we have committed, we've invested significantly in meters, breaker upgrades, and feeder upgrades, and it is our preference to provide electric.
Thank you for those responses, Ms. Meinerich. And my understanding is that you're doing that also so that you can electrify facilities going forward. But the goal, if I'm inferring properly, is not just getting that in time to electrify facilities, but doing everything you can to get that in place for highline drilling on all of these wells.
Yes, we are doing everything we can with utilities.
Thank you. I appreciate that, and appreciate your highlight of the tier 4 engines note as well. That's all the questions I have right now, Mr. Chair.
Thank you, Commissioner Ackerman. Further questions of the applicant? All right, seeing no further questions, commissioners, well, first off, all the witnesses can unvisualize or remove visualization so I can see my fellow commissioners. We would move to deliberations on the comprehensive area plan first. Commissioner Ackerman?
Thanks, Mr. Chair. I'll lead off since I'm blabbing already, but this is a great example, I think, of a difficult situation. I mean, we hear often from the public at large, why are you developing near our neighborhoods? Why are you developing near our homes? And then opportunities that operators take to develop far from those locations often are difficult locations for wildlife. Also, this falls within the ozone area, and so I feel like it really illustrates the example that there are trade-offs and there are difficulties associated with drilling no matter where an operator drills. Here was a situation where the operator had all of their locations located outside of mapped wildlife habitat, mapped high priority wildlife habitat at the inception of this project. And as per our regulations, we allow for annual updates to those HPH maps on behalf of CPW. We did it no more than annually in order to allow adjustments. I think the operator in this case has certainly worked with CPW in an appropriate fashion in difficult circumstances, and they've mulled over a number of alternatives and opportunities to improve the approach to wildlife here. Sometimes that does bleed over into some timing stipulations in high priority habitat, as is the case here. I think 7 of 9 of the most difficult or I guess extensive phases of development are taking place outside of those timing limitations, which to me illustrates efforts to do everything that they can to drill a number of wells, but keep it outside of the timing stipulations to the extent possible. And to me, represents an appropriate spillover into those timing limitations with the BMPs for further minimization associated with that spillover, such as full wrap sound walls to be constructed prior to those phases. And so to me, it certainly adequately represents coordination with CPW. I have no reason to not expect that this operator will continue to do the same with OGDP2 and the difficult potential locations of OGDP2 when we see it come back before us. There are certainly a number of great BMPs associated with a cap that we had hoped would come up when we see caps. The planning of 3-phase takeaway, the planning for electrification of facilities, and also for electrification of drill rigs, ideally. It still continues to cause me concern that we see soft language like this. As my hope going into caps was the intent is to provide that infrastructure and be able to assure that infrastructure is in place. I do understand, as Ms. Meinerich said, that it requires a third party, and it is always somewhat unsure as they move forward with electrification and highline electrification. I certainly would like to keep an eye on this one to see how that electrification is able to extend to this rural area in time for drilling these wells. But I generally believe this is a well done cap. I think it's, I appreciate the consolidation that's taken place as well of locations and the extensive work that's gone forth. And I'm going to be in favor of the cap moving forward. I'm also going to vote in favor of OGDP 1.
Thank you very much for leading off. I'm in agreement. Others with thoughts? Commissioner Messner?
Just briefly, I want to agree with Commissioner Ackerman and the points that he brought up. I think it was well said, and I don't think I can add anything more to it. I think it's interesting that we just heard the cumulative impacts report presentation before this and how it talked about this challenge with, seeing more OGDPs being located further from homes, but yet seeing additional OGDPs being sited in high priority habitats. And I think this is an example of that, the trade-offs and the decision making, the challenges of the decision making associated with that. And so I think the applicant has taken significant steps towards, avoiding, minimizing, mitigating impacts. I think Commissioner Ackerman brought up some good points of things that I also would like to keep an eye on associated with the electrification, and also would be interested in seeing the level and success of the produced water reuse and recycling associated with this comprehensive area plan, as it allows for the timeframes to be able to build out that infrastructure and have more successful infrastructure created. So, but with all of that, I'm certainly in support of the OGDP and the CAP application.
Further deliberations on the cap? Seeing none, do we have a motion? Commissioner Cross, you can give your deliberative thoughts, and then I'll call on Commissioner Ackerman for a motion.
Sure. I was just going to say I agree with my fellow commissioners' comments thus far, and I will also be voting in favor. I was going to make a motion, but I'm happy to leave that to Commissioner Ackerman.
Commissioner Ackerman.
Thank you, Mr. Chair. I think it can be fairly simple, but you can correct me if I'm wrong. I think that I can make a motion to approve the cap as presented and include in that approval OGDP 1 as presented. I didn't see any conditions of approval or other matters that needed to be taken into account, but perhaps Councilor Davenport can correct me if I'm mistaken.
Thanks, Commissioner Ackerman. I'd suggest separate motions for the cap and the OGDP. Other than that, if that is the commission's pleasure, and I understand your motion to be as presented in the amended application, which I believe is dated November 5th, 2024, as well as discussed in the director's recommendation.
Thank you for that clarification, and of course, including the testimony of today. So, Mr. Chair, I, with those statements by Councilor Davenport, would make a motion for approval of the cap as stated by Councilor Davenport.
AG Davenport, does the motion need to provide a termination date on the cap? It was testified to July 14th, 2031, maybe?
Yes, that's a standard 6-year duration for a cap as provided in the rules. Assuming its approval as presented in the application, director's recommendation states a termination date of, I can't remember the day and month, but 2031, that's sufficient.
Okay. I would second the motion. Do we have further discussion on the motion to approve the cap? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. We've kind of already deliberated a bit on the OGDP, but does anyone have further discussions on the OGDP? And AG Davenport, for purposes of a motion, it's just to approve the OGDP. I don't think there was anything.
Yes, as presented, I do not believe, if you'll give me 1 minute, I will double check the director's recommendation and make sure there's no recommended conditions of approval in it. But yes, I'm not seeing anything. So that would be a motion to approve the OGDP as presented if that's the commission's pleasure.
So moved. Do we have a second?
Second. Second.
Motion and a second. Is there further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? That motion too carries. Thanks, Mr. McGee, to you and your client, and thanks to staff for what I know was a ton of work that went into this. So with that, we've cleared dockets 0093 and 0094. Let's
Hey,
get
Robbins.
oh, go ahead.
I believe the motion was, or the motion may have been incorrect as to the termination date. It wasn't for the 6-year standard term. It's close to 6 years, but it should have been extended to run with the term of the state unit, which would have been the July 14th, 2031 date. It's a difference of about a month. So
I had that. That's the
application.
date I threw out. So I
Yes.
actually was right. AG Davenport, if you could revisualize.
And it's for that and the OGDP as well.
What should we do here, if anything?
So I believe the motion for the cap was to approve as presented in the application of the director's recommendation. So I think we can consider that approval to be to that July date in 2031 as requested by the applicant. The OGDP, Mr. McKee, I'm sorry, would you restate what you just said in regard to the OGDP?
We're also requesting that the OGDP and the Form 2As to run that same time frame to be extended to run with the state unit to the July 31st or July 14th, 2031 date, excuse me. And I believe that is as presented as well. And I think that was the motion you did approve for that one.
Okay, so given that the motion has already been for the OGDP as presented, and that was in the date, if the commission doesn't need to revisit that matter, then I don't believe a new motion is necessary.
Okay, and we've got this record, and the order that you're going to draft will identify these issues, correct, Mr. Davenport?
I or hearing officer, yes.
Yeah. Is that okay, Mr. McGee?
Yep, we will work to get those in the order, and thank you very much.
All right, very good. Let's take a few minutes and get docket 240900228 up. We need to get the lawyers for the cities and towns petitioners as well as the lawyers for KPK. It's 129. Let's return at 135. All right, we're back. 240900228 is the docket number. It is 135. If all counsel of record could visualize.
Sorry about that.
Once again, just for process, entries of appearance, Mr. Prescott.
Thank you, Chair. Stephen Lewis Prescott on behalf of the city of Tacona.
Mr. Sarah.
Thank you, Matt Sura for the town of Frederick.
Mr. Schwartzendruber.
Good afternoon, Mr. Chair. Nick Schwartzendruber on behalf of KP Kaufman.
Mr. McGowan.
Chris McGowan on behalf of KP Kaufman. Thank you, Mr. Chair.
All right. We got all our lawyers identified, so that's step one.
Mr. Chair.
Oh, Mr. Boudreau. I forgot a lawyer.
It's okay. Ben Boudreau on behalf of ECMC staff.
Not used to having staff involved. All right. Let's talk procedural matters first before we jump into the merits. As I see it, and we've got a lot of filings here recently. I've got a motion to recuse filed by KPK. I've got a motion objecting to the expert report or the amended expert report of Ms. Lencioni. Let's do that one first because you filed that just to make a record. I've already ruled on that. And I'm not planning on undoing that ruling. So are we good there, Mr. Schwartzendruber?
I think that adequately summarizes where we're at on that. So thank you, Mr. Chair.
Okay. Are there other procedural matters out there before we start with the motion to recuse? Raise your hand if you got anything else. Mr. Sura?
Much like the corrected report for Frederick, there was a corrected report, Exhibit GGG, that was placed into the record that makes the same correction for one well in Dacono, Coslet A4. And we'd like to have that submitted into the record.
And that's filed with us.
It is. It's been e-filed last week.
All right, Mr. Schwarzenegger.
Mr. Chair, I guess our rationale is that if the other one's being admitted, this one likely will as well, but we do object as being out of time and without leave from the hearing officer.
Okay, and for the similar reason, we'll go ahead and admit it with your objection noted. Any other procedural motions? All right, Mr. McGowan, you filed a motion, or you and Mr. Schwarzenegger, I'm not sure whom, but KPK filed a motion to recuse one of the seated commissioners, Commissioner John Messner. I do not need, or I don't know if John does either, but I don't need argument on that from either yourself or the city petitioners or Mr. Goudreau. I would like to recognize AAG Davenport. We don't deal with this often. If you could walk us through what we need to do to process this motion.
Yes, thanks, Chair. The commission does have an applicable rule. In this case, it's Rule 514. That rule provides in 514 B2, B as in boy, 2, that in response to an assertion of a conflict of interest, which is how I judge the motion for recusal, that first a commissioner makes, the commissioner against which that conflict of interest is asserted makes their own decision on whether or not they will voluntarily withdraw. So the first step in this would be to, I believe, provide Commissioner Messner an opportunity to address it and decide whether or not he will voluntarily withdraw. Now, there's an additional step. The rule specifically provides that if the commissioner does not agree to withdraw, the other commissioners will vote on whether or not a conflict of interest exists. So assuming, or in the event that Commissioner Messner does not voluntarily withdraw, then we would need to go to that second step and have a commission, full commission, excluding Commissioner Messner from voting, decide whether or not to effectively require Commissioner Messner to recuse himself.
Okay, thanks for setting the ground rules there. Commissioner Messner, my first is just a question. This came in during our other work today. Have you had an adequate time to review the motion to be able to articulate your position?
I have, Mr. Chair. Thank you.
Go for it then. Floor is yours.
Thanks. I've reviewed the motion requesting that I be recused from this matter, and I individually do not intend to withdraw myself from these proceedings. I take my obligations as a commissioner seriously, and in all matters before me, including this proceeding, I am candid, honest, and forthright in my questioning of all witnesses in order to better understand perspectives and arguments presented in these matters. I do not prejudge matters. I base my decisions on the evidence presented, regardless of the parties involved. As a commissioner, I have an obligation to provide my honest opinions of the evidence and testimony presented. I did that in this and other matters to which KPK was a party. However, my comments were specific to the testimony presented for a particular matter and were not intended to be statements of my opinion of KPK or its witnesses in all cases. And in all proceedings, including this one, I undertake my responsibilities with high integrity, and my decision-making regarding matters is unbiased and impartial. The record of my work contains many examples of this impartiality and unbiased decision-making, including decisions on the record in regards to matters concerning KPK, where I have deliberated and decided both in support and against positions that KPK has taken and helped mediate outcomes that created positive opportunities for KPK. Further, the affidavit misquotes me. I see no reason that I cannot continue this record of integrity and unbiased and impartial review in these proceedings moving forward. Thank you, Mr. Chair. That's my statement.
Okay, great. Thanks for providing us with that response. Under 514B2, If the commissioner does not agree to withdraw, the other commissioners will vote on whether a conflict of interest exists. So I think we need to undertake that part of the rule now. I would move that, in my opinion, no conflict of interest exists, and you should be allowed to continue on as a sitting commissioner on this docket.
Second.
Motion and a second. Is there further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. And anybody no? All right, let the record reflect that myself, Commissioner Robbins, Commissioner Ackerman, Commissioner Cross, and Commissioner Oath all voted that there was no conflict of interest, and Commissioner Messner will be allowed to continue on as a commissioner on this docket. Okay, I think that does away with our procedural matters. And let me just sort of lay out where I think we're going next, and then I'll make sure the parties agree with me. It seems like we've got the KP Cross of Miss Lencioni next. And then let's see, cities, you're done, right? You don't have any further rebuttal or other testimony. Is that right?
Just closing.
Just closing. And KPK, are after Cross of Lencioni, do you have any additional testimony, rebuttal or otherwise?
Mr. Chair, I think we were going to put on Ms. Clark again for maybe a 10-minute, 15-minute presentation, something like that.
Okay. And then Mr. Boudreau, did staff have rebuttal that it desired to present?
No, Mr. Chair, we feel like the commissioners covered all the topics we wanted to cover during commissioner questions, but we do have Mr. Duranlo and Ms. Byrne available if the commissioners have further questions for them.
Okay. Then let's bring up Miss Lencioni, if she could visualize herself.
Chair, Ms.
Yeah.
Lencioni is calling in, I believe, so I don't think she's going to be able to visualize herself.
Well,
What
can
we've
she,
done.
She is online and awaiting to be visualized, I guess.
Oh,
well, Miss Lencioni, can you hear me?
I can hear you. Can you hear me?
I can hear you just fine. Do you have visual capabilities? I know you're halfway around the world.
I do have visual capability. I don't see.
Give me 1 second, then
of-
I'm going to promote you to a panelist, Ms. Lencioni.
Okay.
Okay.
Mr. Smeltz, I think she's already a panelist.
There we go.
All right, Miss Lencioni, are you able to visualize yourself now? There we go. Hey, we can see you. Thank you very much. And we do apologize for interrupting you at probably an awkward time of day or night, but we appreciate you being with us.
I understand. Thank you. That's fine.
All right. The attorneys for KPK have an opportunity to ask you some questions on cross-examination. I would remind you that you remain under oath. And with that, Mr. Schwartzendruber, the witness is yours.
All right. Thank you, Mr. Chair. And thank you, Ms. Lencioni, for appearing for this. I do hate to bother you while you're on vacation. I don't know what time it is there, but it's afternoon, so I'll say good afternoon to you. We've looked at corrected reports, RR and GGG, and I just wanted to confirm further corrected report RR pertaining to Frederick, that did change the economic analysis for each well within the town of Frederick, correct?
Correct.
And then the same thing, even though the error, which we'll talk about relating to shrinkage, didn't pertain to every well within Dacono, but the economic analysis for all of the wells in Dacono also changed in your most recent report, correct?
Yes, because of the change in severance tax.
Okay. And so I just want to be clear. So the changes you've made, I mean, you've made changes to all wells. So the new reports and the new slides would supersede your prior ones then?
Correct.
Okay. I want to talk a little bit about the shrinkage factor and that error. And I know this was an explanation for the need for the corrected reports for Frederick and then the one well in Dacono. Is that right?
Correct.
And with this concept of shrinkage, you had planned to apply a 5% shrinkage factor to the wells, for the gas production, but instead accidentally applied a 95% shrinkage factor.
Correct.
Okay. You'd agree with Ms. Lencioni, none of your prior reports even mentioned the concept of shrinkage, correct?
That's correct. I neglected to state the shrinkage factor in my summary of economic parameters.
And none of them actually applied a 5% shrinkage factor either, correct?
No, a 95% was applied.
But even as to the town of Frederick, though, I'm sorry, the city of Dacono, there was no shrinkage factor applied to all wells, but other than the one well, correct?
Correct.
And so if you remember Mr. Lewis Prescott cross-examining Ms. Clark about assumptions and limitations in her report, were you there for that?
Yes.
Wouldn't shrinkage have been an assumption that would have at least been mentioned if it was your intention to apply a shrinkage factor?
If it was her intention?
No, what I'm wondering is wouldn't it have been appeared in your report as a assumption or a limitation that you were intending to apply a shrinkage factor even if you didn't? Wouldn't that have been something that should be stated?
It should have been there. I grant you that. Yes.
Okay. What is shrinkage?
Shrinkage represents the difference between the volume of gas measured at a well level as produced and the volume of gas actually sold and paid for.
Okay, and what typically causes the reduction of production volumes versus sales volumes then?
And there's several things that go into shrinkage. If the gas is being processed and natural gas liquids removed, you'll have a large shrinkage factor to account for the fact that the natural gas liquids take considerable amount of volume out of the gas. Other than that, sometimes there's small amounts of fuel usage. Sometimes there are losses in the lines between the production meter and the sales meter. Sometimes it's just the difference in the accuracy of the two meters, but it simply represents the difference between the sales meter and the production meter.
Okay. And would you agree with me that standard practice with decline curve analysis is to use production volumes as opposed to sales volumes?
Yeah, the shrinkage factor doesn't come into the decline curve analysis. It just comes into the economic calculations.
Okay. And wouldn't you agree with me that it's uncommon or not customary to apply shrinkage to those economic analyses unless you have a basis to do so?
I agree. You do need a basis to do so, and I did have one.
Okay. And let's move to pricing. You had, but then your amended reports, though, your corrected reports did not apply any shrinkage factor.
That's correct.
Okay. Moving on to pricing, you used NYMEX future strip pricing for all of your reports for both oil and gas?
Correct.
And you updated future strip pricing between your September 2024 and your May 2025 reports, correct?
Correct.
And that resulted in lower prices being applied in your May 2025 reports than the September reports. Is that right?
Correct.
And the May report prices were taken from NYMEX strip pricing from March of 2025, correct?
That's when I began that analysis, yes.
And you would agree with me that more than 3 months have passed since that time?
Yes.
But you did not similarly update your strip pricing for your June reports, did you?
I did not. I looked at what the strips were running at that time, and they were similar. So I did not think it was necessary to update them.
And for both of your corrected reports, you continue to contend that KPK's cost data excludes well repair, pipeline repair, equipment repair and maintenance, and other items, correct?
Correct.
And so you're rejecting KPK's business records and the testimony that's been submitted, other than remediation and plugging and abandonment, which I'm excluding, but you're kind of rejecting KPK's lease operating expenses that they've presented in this hearing in your analysis, correct?
I'm adjusting them, yes.
Well, you're not using the KPK's cost data. You've adjusted them to include additional costs because you don't believe that KPKs are comprehensive.
Correct.
Okay. And you're sticking with your original cost assumptions that you had in your May reports, right?
Yes.
And those additional costs that you put into your report, those were based on, again, conferral with an undisclosed colleague, right?
Partially, yes.
And also a comparison to an undisclosed project for an undisclosed operator.
Correct.
And you can't say who that operator is.
I could say that.
Okay, who's the operator?
The operator is Fremont Petroleum.
And so the Fremont Petroleum wells, those I suspect are not Shannon Sussex wells within Spindlefield, are they?
They are not.
Okay. And Fremont Petroleum isn't a vertically integrated operator with its own service companies, are they?
They are not.
And do you know whether Fremont Petroleum has essentially no other non-operated working interest owners?
They did not.
They do not have non-operated working interest owners, or they do?
They do not have partners in their working interests.
Okay. And how many wells do they operate in this project that you're using as a comparison?
I believe it's about 30.
Okay. Pretty far off from the 1,200, though, that entails the Spindlefield, correct?
That's true.
Okay. And then also with respect to cost, you continue to only use KPK's 2024 data, despite being provided 5 years of data for the subject wells, correct?
That's correct.
Okay. Let's go to remediation costs. And you can continue to contend that remediation costs should be included in what you call field or group level costs. Is that right?
Yes.
And in your report, that's $572 a month?
Yes.
Okay. And that $572 per month relates to existing projects based on a $24 million estimate from staff, ECMC staff, correct?
Correct.
You didn't endeavor then to look at the actual remediation projects associated with the subject wells to determine costs, did you?
No, I didn't.
And you discussed pipeline leaks in your corrected report, but similarly, you're not aware of any existing pipeline leaks associated with the subject wells for which you are basing costs.
Correct.
Correct, you are not.
I am not.
Okay. And so you've obviously not quantified remediation costs and pipeline repair costs specifically for the subject wells.
That's correct.
And you recall last time I was questioning you, Ms. Lencioni, we talked a little bit about how you computed barrels of oil per day and MCF per day, basically taking cumulative production and dividing it by the number of days. Do you recall that line of testimony?
I do.
And not taking into account the number of days that a well was online. In your corrected reports, did you continue to compute production per day using the same methodology?
Yes.
Okay. And in your corrected reports, you continue to use a 10% annual discount rate for all of your economics, correct?
That's true. It's in there, but I don't really do anything with the net present value.
What does that mean? I mean, you applied a 10% annual discount rate for your net present value determinations, did you not?
Yes, but in the well-by-well analysis, net present value isn't even mentioned. I discuss undiscounted cash flow and gross revenue.
I see. But in your well economics and determining whether or not the wells were economic, you did apply a 10% discount factor per annum.
And I also considered the undiscounted cash flow. But
So,
yes,
yes to my question.
the primary discount factor that was applied was 10%. That's correct.
Okay.
As a standard in the industry.
And you heard Ms. Clark testify that she thought a discount rate that was more reflective of actual inflation rates historically known would be more appropriate given the nature of the proceedings. You must disagree with that?
Correct.
Okay. But you'd agree with me that a 3% discount rate is much closer to historical inflation rates than 10% per annum, wouldn't you?
Yeah, the discount rate is not intended to reflect inflation.
Well, it's discounted 10% every year, though, correct?
Correct.
And would you agree with me that some of the wells within the city of Dacono and the town of Frederick are actively producing some of the wells you evaluated?
Yes,
and the remainder are shut in.
correct.
And each of these shut-in wells were producing in varying degrees before they were shut in, correct?
Correct.
Okay. Would you agree with me that if a well is actively producing and the production is being sold, that well is in use?
Yes.
I want to talk a little bit about the corrected report for Frederick specifically. I understand you didn't change any of your production trend lines. Is that right?
Correct.
Okay. And I asked you last time, and I don't think we got very far with the line of questioning, but you continue to remove the Pan Am AE5 well from that report. Is that right?
I don't remember the details of that well, but I know there were some wells that were removed.
Okay. On what basis were the wells that you removed?
When Mr. Sura told me that they were no longer part of the town's application.
Okay. And then you only ran there. Let me back up. There's 25 wells within the town of Frederick that are subject to the application, correct?
Yes.
And you ran economic analysis or decline curves and economic analysis in your report for only 17 of those wells, right?
Yes.
And that represents the 8 producing wells and 9 that are shut in, right?
Yes.
And then so economic analysis and decline curves were not run on the remaining 8 wells, correct?
Not in the report. That's correct.
Right. And you had just simply concluded that no further production or revenue is expected from those wells, right?
No, I concluded that it was not going to be economic based on the analysis of the 3 wells that had been shut in since 2021 that I did analyze.
You didn't show your work though in terms of the economics for those 8 wells, did you, within your reports?
No, I did not.
Okay. I want to talk about figure 5.1 in your report, and I can pull it up if I need to, but actually let me go ahead and do that. Bear with me just a second. Ms. Lencioni, can you see? Oh, I might have messed this up here. Hang on. Okay, can you see the report there?
Yes.
And this is the figure 5.1 in your report relating to the Morgan Unit A1 well. Do you recall that discussion?
Yes.
And in this particular well, you would agree with me that you didn't forecast oil at all, right?
That's correct.
And that's one of actually quite a few wells where you didn't forecast oil at all, right?
That's correct.
And so by not forecasting any oil with those wells, any value that may have been added through oil production was not accounted for, correct?
That's correct.
And this particular well, you say that you essentially, I think that you didn't forecast oil because you didn't think that the well would ever produce oil again, right?
Not based on the most recent mode of its operation, correct?
Well, you surmise that the most recent mode of the operation must be a broken pump or that it's just uneconomic for KPK to produce the oil, right?
Or that they're not using a pump and the gas cannot lift the liquids. Yes.
Okay, so those are the scenarios that you have a hunch may have existed, but is this another example where maybe let me rephrase my question. Did you reach out to KPK to discuss with them what exactly was happening with the oil production on this well to inform what you might believe would have been going on with the well?
I did not.
Okay. And you gave like 3 different alternatives to what may have been going on, at least 2, correct?
Yes.
Wouldn't it have behooved you if the data was ambiguous to reach out to KPK to discuss what may have been going on with the well?
Seeing as how the well had only made a couple of barrels of oil in the past 5, 6, 7 years, I didn't think it was relevant. If there was a problem they intended to fix, they should have fixed it already.
Even if the reservoir showed, I know you only have 10 years of production history, but even if the production history showed 30 years of oil previously, you don't believe it would be relevant to contact KPK to discuss whether oil production could be reinstated?
Correct.
Okay. And again, in your report, I'll stop the share. I think that's all the questions I have on that. You talk about carbon capture and underground storage, and you say that it's not a viable option for these wells, correct?
Correct.
And one point you make is that no project is underway. There's nothing in the literature. There's nothing to indicate permitting or anything like that associated with these wells for such a project, right?
Correct.
Well, you'd agree with me that any such project would necessarily follow the end of the productive life after the end of both primary recovery and any secondary recovery?
No.
You don't think carbon capture and sequestration would follow the production from the wells?
It depends. As I understand it, the nature of the carbon capture program that KPK has been discussing is related to CO2 EOR project, which would not need to wait until the end of primary or secondary recovery. It could be instituted at any time.
Oh, okay. So you're not making a distinction between secondary and tertiary recovery on one hand versus storage on the other.
We can do that if you like. If it's simply storage not related to an EOR project, then yes, it would be after any primary or secondary recovery project involving the wells.
Okay. And Rule 211 talks about identified for future beneficial uses, correct?
Yes.
Is it your testimony that such an identified beneficial use must necessarily involve existing plans, permits, even if the operator believes that such a project is decades away?
If such a project is decades away, I still think there would need to be something more concrete to make the project less highly speculative in light of the drawbacks for the project occurring in this reservoir, in this area.
Do you need decades of planning time for a secondary unitization plan?
I wouldn't expect decades, no.
What about for a carbon capture and storage plan?
I would also not expect decades on that. Years, yes, indeed, but probably not decades.
Okay. And just to be clear, within the town of Frederick, using only the well level cost data as augmented by you in your report, there's still 7 wells that are capable of production to sustain those costs into the future, at least for some period of time, correct?
Correct.
Okay. And they're only uneconomic if you assume that that your further group level costs and financial assurance costs are accepted, correct?
Correct.
Okay. And then you also compare gross revenues to plugging and abandonment costs for each of these wells, correct?
Correct.
But your gross really isn't gross. You take it net of royalties, correct?
Correct.
Okay. I want to talk now about the Dacono report. Again, I just want to confirm the trend lines in the corrected report similarly did not change from the original trend lines, correct?
Correct.
Okay. And for the Dacono wells, 11 of the 17 wells are capable of sustaining well level costs, even as they've been augmented by you, correct?
That sounds about right.
Okay. Thank you, Ms. Lencioni. I have nothing further.
All right, Mr. Sura, redirect.
Yes, thank you. Ms. Lencioni, just to be clear, what 2 changes were made to the Dacono and Frederick wells in your report on their economic projections?
The shrinkage factor was taken out entirely and the production tax rate was lowered.
Would those changes increase or decrease the economic projections, economic capabilities of those wells?
Increase.
And are those changes in line with KP Kaufman's own assumptions in their own reports?
Yes.
KP Kaufman has stated that they disagree with your economic projections. What goes into an economic projection?
The decline curve analysis, the price forecast, the estimate of costs, taxes, royalties.
How many economic projections have you conducted over your career?
Thousands and thousands.
Who have you conducted them for?
For my employers, Arco Oil and Gas, Enron Oil and Gas, and as a consultant for numerous other operating companies, working interest owners, mineral interest owners.
Why would so many need to be conducted? Where do those reports go to?
Mr. Chair, I'm going to object on the basis of this not really being relevant to anything that was discussed on Director Cross. It's just bolstering testimony.
Not at all. They were asking why she didn't include certain things, and I think that this gives reasons why she included things and why she didn't.
I'll allow it. Keep going.
There are various reasons for these analyses. Many of them are for reserve estimates for SEC reporting, for reporting to other stock exchanges in other countries, for obtaining bank loans, for valuations for IRS purposes, and for valuations for property sales and acquisitions.
Are there any agencies that receive this information?
Are there any, beg your pardon?
Agencies that this information is sent to?
Yes.
Which ones?
So the Securities Exchange Commission for the United States has received many of my analyses. Securities agencies in other countries, banks.
Okay,
the
so
IRS.
in every one of these economic projections, do you also do a decline curve analysis?
In general, yes.
Okay, so there are also thousands of decline curve analyses?
Yes.
What time frame is typically considered in a decline curve?
There's not a specific required time frame, but my practice is that the decline trends that have been established in the most recent time, the last year, especially the last several months, is most reflective of the well's current performance and what it's likely to do in the future. Occasionally, when that performance may be sporadic and difficult to forecast over that recent time frame, I go back and look at previous production to get a trend, and then that trend is applied to the most recent average production.
What are some of the concerns about a well that hasn't produced in numerous years?
If a well has not produced, for example, if it has produced gas but no oil over recent years, then I would never project my base case to include oil production. It's possible that that well could have proved developed non-producing oil production if the company understood, the operating company understood why the well was not producing oil and had a plan to fix.
I think that Ms. Lencioni has frozen on my side.
Oil. If the
She's
well
back.
has not produced at all.
Ms. Lencioni, unfortunately, you froze there for a bit. So could you kind of repeat this answer?
Absolutely. I was talking about if a well that may have produced gas but not oil for the past several years, And in such a case, I would never project oil production into the future as my base case. And there could be circumstances where I would project oil production as proved developed non-producing stream if the operating company understood why the well was not producing oil any longer and had a plan to fix whatever the problem was and a planned time frame they were going to conduct that fix and a cost estimate for that, then that could be a secondary proved developed non-producing projection of oil production. If a well has not produced at all in several years, then the continuing production, if the well is reactivated, has a lot of uncertainties in it. The well could and often might come on at a slightly higher rate initially, which we would call flush production. This would be expected to be a short time frame, and then the well would decline back to its previous production rate or lower. Alternatively, the well might not come back on at all and might need investment to work on the downhole equipment, or the reservoir might need an acid job to reestablish production. So when I've reforecast in this analysis wells to come back on production, I was optimistic and assumed that it could come back on to its previous trend and previous rates with no investments.
And that would include it for those wells that were producing no oil. They would continue to produce no oil. Is that correct?
That's correct.
So there seemed to be some confusion from KP Kaufman as to the use of a discount rate and what goes into that. Can you explain what a discount rate is and how
the discount rate is in general to reflect the time value of money. The fact that if I had $1,000 today, it's worth more to me than if I had $1,000 10 years from now, because I can do other things with it now. That's the purpose of it, and generally what goes into it, it's often related to a weighted average cost of capital for a company in particular, or for the industry as a whole, and 10% is a standard in the industry for reporting reserves and for reporting to the SEC.
Thank you. Why didn't you complete economic forecasts for all of Frederick's wells?
When did I complete it?
Why didn't you complete economic forecasts for all of Frederick's wells?
I didn't, because I understood KPK's objection that several of these wells had been shut in for years because of a commission order. And so I looked at that group of wells and selected 3 of them that were among the best producers of that group. And I did conduct an analysis on those 3 wells and concluded that they were uneconomic, no longer used or useful. So the conclusion followed that the other wells, which were producing similarly or worse, were also no longer used or useful.
Did you choose the highest producers of those wells?
I did.
So if the commission would like more analysis of the other wells, where else could they look?
Those wells were all included in KPK's analysis.
And in looking at KPK's analysis, I'm sure you've looked at that. What would they find in looking at their analyses for those wells?
So 3 of those wells in KPK's analysis also were uneconomic without the inclusion of their average value of a refrac. And the others were of relatively low value.
Okay, well, that's all the questions I have for you. Thank you.
Okay, thank you for that. Mr. Boudreau, I assumed you did not want cross on this witness.
No, thank you, Mr. Chair.
Okay. All right. Well, with that, I believe Ms. Lencioni, you can go back to doing whatever it was you were doing. And thank you very, very much for taking time out of whatever part of the day or night it is and being with us. We appreciate it.
You're welcome.
Okay. Oh, hold on, Miss Lencioni. One quick hold. Does any commissioner have a question for Miss Lencioni? All right, I'm not seeing commissioner questions, so you can now go. Thank you.
Okay.
All
Bye.
right. All right. Are we at this point where we're going to do closing arguments? Mr. Sarah, Mr. Prescott?
I believe so, but I saw Commissioner Cross's hand just raised. I didn't know if there were questions from Mr. Duranlo before we move to closings.
Okay. Commissioner Cross?
Thank you, Mr. Chair. I would like to ask a couple questions of Mr. Duranlo, and if all right, I think I can probably ask him, but it might be more appropriate for one question from Ms. Byrne instead, related to MITs.
Why don't we raise both of them? Mr. Duranlo, aye. You remain under oath, so testify accordingly. And if we could raise Ms. Byrne. Hearing Officer Smeltz, are you working on that? Oh, there we go.
Yes, we are.
Okay, AG Davenport, do you want to visualize yourself and swear in the witness?
You're under oath too.
Yes, I believe I already have sworn in Mr. Duranlo. I could be wrong about that, but I'd simply inform Mr. Duranlo and Ms. Byrne that you should consider yourself still under oath.
Oh, okay. I didn't know if we had sworn in both. That sounds great. Commissioner Cross, go ahead with your questions.
Thank you, Mr. Chair, and thank you again for taking the time to come back. I just want to try and ask a couple clarifying questions, if I might. The first, and perhaps the MIT issue might be more appropriate. There was some testimony previously about MITs being up to date, MITs not being up to date. And Ms. Byrne is the engineering manager. Maybe this is best posed towards you for a question. But can you give us just a clarifying update? Are there outstanding MITs currently with the wells at issue here?
There are outstanding MITs for the wells in question.
And do you know how many outstanding MITs there are?
I do not know the exact number of outstanding MITs. All the ones that are currently shut in would, I believe, are overdue for MITs.
So all the ones shut in are. Okay. That is helpful. And the other questions I would like to go to, there was also some discussion of the 901A orders. And again, for clarification purposes, out of the 3 901A orders, 2 of them are still in force and 1 has been lifted. Is that correct?
I thought they were all still in process, but not current, I guess.
Okay.
Craig knows. Mr. Durham.
Mr. Duranlo.
Yeah, I can answer that question. I just don't want to break protocol.
Go ahead, Mr. Duranlo.
Thank you. So the 2021, the first 901A order is still in effect. The 2022 901A order that was for one issue with a dozen or 2 related wells, that one was complied with and those wells were brought back online. And then the 2024 901A order that was more related to flow lines, but also encompassed some spills. That 901A order is still in effect.
Okay. So again, for clarity purposes, at least part of the reason these, if not the entirety of the reason these wells are shutting currently, is because of the 901A order. Plural.
I would agree that the 901A order is still being in effect is causing some of KPK's wells to be required to be shut in. I would have to look very closely and cross-reference to answer that for all the wells that are specific at issue here. There may be other reasons for them to have wells shut in.
Okay. But regardless, for those shut-ins, we are behind on the current mechanical integrity tests.
Yes.
Okay. And I think big picture, as we look back at the 901A orders, what in staff view, what is the purpose of those 901A orders?
I'll take that question. So again, going back to the original reason that those 901A orders were issued was, significant, a number of spills that had been reported and that were falling behind on reporting and field work. And coupled with some safety incidents that ECMC felt needed to be addressed relatively immediately, the 901A orders were issued, and really in hopes that that would spur the action, by shutting in the wells, would spur the action necessary to get the remediation projects moving towards closure. So the intent of the 901A orders wasn't to keep wells shut in. The intent of the 901A orders was to spur action to get the spills and remediation projects cleaned up and closed, and thereby allowing the operator to resume production.
So it's both a matter of safety and also a matter of incentive.
I'm sorry, the question again?
Safety and
Sorry, it's both a matter of safety as well as a matter of incentive.
Yes.
Okay. But as you noted, 2 of the 3 are still in place, so maybe not enough incentive to get some of these done, at least to this point. Some of the remediation requirements.
I would say apparently not.
Okay. And then the other thing I just want to touch on is some of the testimony that was raised by Mr. Peterson as well. There was some conversation that in his experience, there was other environmental consultants never deal with forms being denied. Their work with KPK is the only time this has happened. And I just want to get staff's perspective on this, especially when it comes to the Form 27s, because I know a lot of the Form 19s have already been handled here. But with respect to the Form 27s, is it uncommon for staff to deny Form 27s when they come in, whether it be from a consultant or directly from an operator, regardless of what operator it's attending to?
I don't have the exact number in front of me, but staff has denied hundreds of Form 27s this calendar year. And
for operators other than KPK.
For operators other than KPK. I don't think that KPK has submitted hundreds of Form 27s this year. So staff, it's not uncommon for staff to deny Forms 27 for a number of reasons.
And in your opinion, is it uncommon for operators or their environmental consultants to then not file Form 27s if a Form 27 is denied, filed updated or amended Form 27s?
Our expectation is if a form is denied, it does enter that form and the attachments into the record. But our expectation, and typically there's a COA to the effect of, another form needs to be filed to correct these issues. And sometimes there's a time, time given on that, and sometimes not. So yeah, our expectation is that they will timely file a replacement form.
Okay. And similarly, there's also an expectation, I know that there was some discussion early on about not just the filing of Form 27s, but also the filing of, I believe it's quarterly updates with respect to plans. And I think your previous testimony, Mr. Duranlo, was there are instances where sometimes there isn't necessarily a substantive update, but it's still required that operators file that updated plan as to what has happened, what intends to be happened, even if sometimes we're just waiting for testing or attenuation, et cetera, correct?
Yeah, absolutely. And that's it's really important. Again, it is, and some of the testimony that I heard from Mr. Peterson was, the work had been done at these sites, and so they didn't pose a risk. If the forms are not filed with us, then we have no way of knowing what was done or whether they're waiting, for business reasons, waiting for the next quarter to do work, or weather reasons or whatnot. And until we are informed that work has been done, we can't make assumptions that of the site conditions. We have to base ECMC has to base our decisions on the status of a site based on the information that is timely provided to us. And again, as I said, ECMC is the arbiter of whether a site is cleaned up and closed in these situations. And we have to make those determinations based on the information that is provided to us. So until we've been provided accurate and timely information about the site, we cannot make those decisions.
Okay. And I presume, sorry, and just kind of jumping back and forth, Ms. Byrne, I assume it's probably the same for an MIT as well. You can't just take the operator's word that the integrity is all right. You have to actually have the information required in the MIT, correct?
Correct. We would expect, that it's documented.
Okay. Thank you. And I think as I'm going through my notes here, I think I just have one final question. And again, maybe Mr. Dramo, this might be best suited for you. Did you hear testimony last week during the hearing? I believe it was from Mr. Kaufman, talking about some of the refracturing that has been done on these wells in the past.
I did.
Okay. And there was some discussion about whether there was anything filed with the commission when those refracturing processes occurred. Do you remember that?
I do.
And do you remember what his answer was?
So my recollection of the testimony was that there were 40-something refracts completed by KPK in the 2004 to 2009 range. And Ms. Byrne reviewed, and the testimony included a comment that there were no reporting requirements at the time. So Ms. Byrne reviewed the Form 5s that were submitted to document hydraulic fracturing from 2003 to 2010, and found 3 reported refracts in that time frame from KPK. We also reviewed the historical rules of the commission, and going back to at least 1998, we found that Rule 308B, big B at the time, was in effect, and in fact those refracts were required to be both permitted and reported in that time period. So none of the 3 out of 40-something that they talked about were reported to us.
So 3 were reported. Were those 3 also applied for before it was done, or just reported after it was done?
I don't know the answer to that question.
Okay. Ms. Byrne, do you know the answer to that question?
Have to clarify, if they did not change the gross interval of the previously perforated interval, there wasn't a requirement to ask ahead of time, but to document after the fact that it happened. If they increased the gross interval, then there was a requirement to document that ahead of time or request that ahead of time. I believe 2 out of the 3 had the prior request.
So, and Mr. Geronimo, I believe you said there was approximately 40 refracts, but apparently only 2 were asked for ahead of time and 3 were reported out of that approximately 40.
Yes, that's what I understood the testimony to be, and that's again the review that we conducted, and thanks for the clarification.
Okay. Thank you. I think those are my only questions.
Commissioner Messner?
Thanks, Mr. Chair, and thanks, Commissioner Cross. You asked a lot of the questions I was going to ask, but I did want to follow up on one other thing regarding the MITs. There was some testimony that was given that indicated that it was not possible to complete an MIT under a 901A order. Is that true?
And I'll refer that to Ms. Byrne.
There should be no preclusion that we would expect that the 901A order is separate from the expectation of the well maintenance. And so the required MITs for the demonstration of mechanical integrity would be an expectation for idle wells.
Okay. That's my only question. Thank you very much.
Other questions for the witnesses? All right, I'm not seeing any further questions. I think we can let these witnesses go.
Mr. Chair,
Oh, Mr. McGowan?
I believe, and maybe I'm mistaken, I believe you did note that we would have an opportunity to ask a few questions of these witnesses after commissioner questions. Last hearing, I believe that was something you had extended to us, if I'm mistaken.
I can't recall. I'll take your word for it. If that's how I acted previously, you've got a chance for a few questions.
All right, just a couple of clarifying questions here. With respect to the MITs, so we had kind of touched on this earlier. If there is, Ms. Byrne, if there's gas in the MITs, that gas would need to be dealt with prior to conducting the MIT, correct?
So if the ask is you need to blow down the well to prep the well for a mechanical integrity test, yes, you would have to blow the well.
And the ways to do that would be
No
venting.
isolation.
You could vent, flare, or sell the gas, correct?
Yes.
Except venting is prohibited, flaring is only allowed under certain circumstances, and you can't sell gas if the Form 10s have been suspended, correct?
So in many instances, it wouldn't be able to flow down the flow line because that's what's the preclusion to producing the well. So that's not the available source. We do expect that emissions are controlled to the best of the ability. And so there are portable combustors that are available to do that. And it also depends whether or not the well is already configured to perform an MIT as to whether or not it needs to have any emissions associated with it.
So under the circumstance that there was a buildup of gas and they were unable to, that they needed to remove it somehow to vent, flare, or sell gas in order to prepare the well for an MIT, that would be a violation of the 901A order, correct? Or other rules prohibiting the venting and flaring of gas.
It would not be a preclusion because there's allowances under 903 for specific tests that's an acknowledgement that sometimes that's the only way it can happen.
Okay.
We do expect that in lieu of venting, that controls are put in place to the best of the ability to control those emissions.
Okay. And as we noted before, the MIT is for informational purposes, correct? Like because the MIT is intended to show the integrity of the wellbore, correct?
Yes.
So if there's no MIT performed, that doesn't necessarily mean there's an issue with the wellbore, correct?
Correct.
Okay. Mr. Durano, real quick, the 901A orders, to your understanding, many of the issues that were articulated in those 901A orders, those related to flow lines, correct?
Many of the spills were from flow lines, if that's what you're asking.
Yeah. Okay. And then under ECMC, flow lines have their own, for example, unique identification number, correct?
Yes, flow line systems, some flow line segments have unique facility ID numbers depending on how they were registered.
Okay. And flow lines themselves can be repaired, addressed, like the concerns surrounding the flow lines can be addressed individually, correct? I.e., my question is that if I need to repair a flow line, if there's a flow line issue, that doesn't necessarily mean that it's the well itself or the well bore or the production from the well is impacted, correct? Or there's an issue with the
That's
well.
correct. If the flow line lacks integrity, it doesn't say anything about the integrity of the well.
You had testified when you last time during commissioner questions that you had noted that your it was your belief that if there's an open remediation project that is at all stages effectively an impact on the public health, safety, and welfare, right? Am I articulating that? I'm kind of summarizing, but am I articulating that fair?
Until a remediation project is closed, it is representative of an open and active environmental impact.
And then I believe Mr. Robbins clarified that by saying there's a range of that, correct? It's like I get used for just by way of example, a scale of 1 to 10, right? There may be some impacts, there may be more impacts, but there's a range of impacts, right? Just by just saying there's an impact to public health, safety, and welfare, that doesn't preclude uh, various stages, I guess, of impact. Am I articulating that well? Do you kind of understand that question?
Yeah, I don't recall talking about a range or a scale of 1 to 10. I do know that we did talk about some, relative severity of impacts.
So, for example, a remediation project could be at a stage where there's just needed to be some forms filed, or it could be at the initial stage where there's more significant work to be done, like excavation and testing, basically, right?
Can you ask that again? I'm sorry.
So for example, I mean, technically, okay, let me put it this way. Technically speaking, when you open a remediation project, at some point during that remediation project, the reason you're opening it up is because you're technically, for example, non-compliant with ECMC rules because you're having to clean up a spill, correct?
Not in all cases. Some remediation projects are open prior to any work being done, but generally, you open a if a remediation project is open for the purposes of spill cleanup, at the beginning of that project, the impacts are likely higher than at the end of that project, if that's where you're going. So that has a scale or a relative scale. The impacts are higher at the beginning of the project.
Perfect. That is exactly what I was getting at. Thanks. And then is it your understanding that even with the 901A orders that KPK has got some no further action on some of the underlying locations or wells subject to the 901A orders?
On some of the remediation spills or remediation projects associated with the 901A orders, I believe there are some. I believe that number is very small relative to the overall number of projects that are wrapped into those. So I would say a couple out of a few dozen, for example.
But some are done. Some have received that.
I believe that's the case, yes.
Okay, thanks. And then you had noted Form 27s are denied regularly. Do you know exactly? I don't speculate or guess, but do you happen to know exactly how many Form 27s of KPKs that have been submitted have been denied?
I don't have that number in front of me. I could certainly get it for you if desired, and depending on the time frame.
And then I'm guessing you wouldn't have that in relation to say, for example, how many were approved either.
Not in work that I've done to prepare for this.
Okay. Do you have a rough idea of how many have been approved versus how many have been denied to KPK? Would you say it's more or less?
I prefer not to speculate. Thank you.
And then, like we said before, same thing with forms 27 or inspections. It's the unknown piece that is a problem for the forms, right? Essentially, you're arguing what you had testified to was that the forms provide knowledge to the commission, correct?
The forms do provide one window into what's happening at the site.
Okay. And I know there's other ways, but just based on the forms, just because I haven't filed the form does not mean that work hasn't been done. And for example, the site is maybe at the end of a remediation project, or there's been significant work done, right? That doesn't necessarily preclude that from being the situation, correct?
Objections, compound questions?
Okay, I can rephrase that. So, if you haven't turned in a form, that means you don't know the status of the site, correct? Is what your argument was.
It provided we haven't been out to inspect or any other means of identifying.
Sure. So if you don't know whether there is an ongoing impact or not, then, correct?
I'm going to object. Like many questions before this have been asked and answered. We're retreading the same ground at this point.
I'm just clarifying his testimony.
Go ahead, Mr. McGowan. If you can get through this, that would be great.
Yep, and I have one more question. Do you happen to know what the violation is, what tier violation it is for failure to file a Form 27?
I'd have to refer to the rules. I don't have that open, the 500 series open in front of me.
Oh, that's perfect. I appreciate it. Thank you very much.
Any redirect, Mr. Boudreau?
Yes, a couple questions, Mr. Chair. Mr. Dronlo, you and Mr. McGowan were discussing earlier degree of impacts associated with open remediation projects. Is that right?
Yes.
Is it possible to know the degree of an impact for an open remediation project if an operator does not regularly report on the remediation project?
It's incredibly difficult.
Would you say it's prudent for ECMC to assume the impacts are existent when there's no information to indicate otherwise?
Objection, that calls for speculation.
I'll withdraw the question. That's all I have, Mr. Chair.
All right. I believe the witnesses are excused. Thank you both very much for being with us this afternoon. All right. With that, I think we are at the place in which the only thing left is closing arguments from the parties. Mr. Schwartzentruber.
Sorry to interrupt you, Mr. Chair. I believe we were going to put on Ms. Clark briefly.
Oh, that's right. I apologize.
Well, that's okay. Thank you. We
Yeah,
would
thanks
like
for
to call
reminding
her
me.
if that's
Let's go ahead and get her back in paneled.
Thank you.
Mr. Schwartzendruber, that's Lily Clark, correct?
Correct.
I'm promoting her to panelist. Oh, there she goes.
Good afternoon, Ms. Clark. You are going to be asked questions by the attorneys from KPK. I would just remind you, you remain under oath. And so with that, Mr. Schwartzendruber, the witness is yours.
Thank you. Ms. Clark, if you would please reintroduce yourself and start with your presentation with sharing your screen, that would be great.
I don't think I have screen sharing capabilities right now. Oh, here we go. Great. So my name is Lily Clark once again, and I am the Director of Engineering at KPK. One thing I wanted to bring up is the amended reports that Ms. Lencioni created for Frederick and Dacono and her reasoning behind the 95% discount that was added to her cash flow analysis was due to shrinkage. Gas shrinkage is not used in decline curve analysis. The textbook definition of shrinkage is the difference between volumes produced from a well or property and volumes sold, which Ms. Lencioni testified to. This textbook says decline curves or other methods that are used to forecast future reserves are based on production rather than sales. Also important to note that shrinkage was not applied to Dacono's Exhibit SS, which was one that didn't have the 95% error. And it was never mentioned in Exhibits M, SS, RR, or Triple E. The shrinkage issue was only mentioned in the amended reports after that 95% discount error was called out. Next, I want to talk about KPK's LOEs. As I previously testified, the lease operating expense that I used for my analysis was $379 per well per month. This came from all of the Sussex Spindlefield wells, and it was from 2019 to 2024. This number is inclusive of all recurring and non-recurring variable costs, both well and field / group level costs that Ms. Lencioni says are missing from our analysis. We include pumping, workovers, well repair, pipeline repair, replacement parts, field level costs. We even have some overhead in that $379 a month cost. KPK also recognizes that discount rates account for the time value of money. They also account for overcoming investment hurdles and risks of taking on a new project. Because KPK is just operating these wells as we have for decades, we have the right to have a conservative estimate that really the only thing we are overcoming is the time value of money, which is the inflation. We're not overcoming any sort of risk or investment hurdle by producing these wells as we have for decades, which is why we used the 3% discount rate. Here I have the breakdown of my LOE that is $379 a month. I highlight the line items that Ms. Lencioni is saying we're missing and we're not accounting for. All of these green highlighted lines are codes that go into workovers. The yellow lines are all codes that apply to group costs and field level costs. The orange lines can be coded or considered either a direct well cost or a group cost, but they're in there. These purple lines are overhead. So the $379 per month is really a conservative estimate of our lease operating expenses. And so it is very inclusive of all costs to operate these wells, both directly as the well cost and the field level operating expenses for these wells. There's also been a lot of discussion about the reliability of the Netherland Sewell report. Netherland Sewell is an SEC compliant engineering firm. We are referencing a stamped report from this world-renowned engineering firm. I'll read this snip. These pictures here are taken from their website. They're a worldwide leader of petroleum property analysis for industry and financial organizations and government agencies. They deliver high quality, fully integrated engineering, operational, geological, geophysical, petrophysical, and economic solutions for all facets of the upstream energy industry. They're also the #1 choice for SEC reserves reporting, and they have a number of resources in developing its procedures and standards for reserves report to be used in filings with the SEC, including the pricing data and guidance. Netherland Sewell is used for SEC reporting more than any other petroleum consulting firm. They're a very, very reputable firm. The price deck that they used in 2014 is very similar to the pricing I used in my decline curve analysis and economic analysis model for this case. The capital cost to do a Sussex refrac in the Netherland Sewell model was really high, and KPK has instances of Sussex refracs costing half of what was modeled. So again, it's possible that if we were to refrac, we would see even more than that average $74,000 NPV that I mentioned in my report. It's also important to note that the reason we didn't do some of these refracs was because KPK reallocated capital to develop horizontals in 2011 to 2015, and we prioritized remediation in the last several years. So the refrac and recomplete program slowed down, but that program still remains an economically viable project and is very profitable for KPK. We did, in fact, refracture the Grant 4, which is one of the subject wells in this case. It was refractured in May of 2008, which if you look at my decline curve, corresponds with about month 113. Clearly, you can see that there is a massive jump in the production, both in oil and gas. The 6 months before the refrac in May of 2018, the well was averaging 50 barrels per month and 107 MCF per month. After the refrac, the well averaged 162 barrels per month and 395 MCF per month. So again, you can see that these refracs are very successful and add a lot of economic value to these wells. Here I have the ECMC operator guidance sheet for a refrac. This case number 1 is re-stimulating a currently completed formation without the addition of any new perforation status. We don't need any prior approval, so we didn't get it. There was Form 5A and Frac Focus reporting that is required now, but Frac Focus wasn't created until 2011, and I don't believe the Form 5A rules were created before or while we were doing these Sussex refracs. They weren't in effect yet. Here I have an analysis comparison between my own analysis, Miss Lencioni's analysis, and DeCono's Brian Hill's decline curve analysis and the economic viability of each well. Here in this column, you can see KPK's NPV. This is the net present value discounted at 3%, like I said. Important to note that this is a net present value. This is not a gross number. Here's KPK's gross number, no royalties, no taxes. Here's Miss Lencioni's report for those that she says has a positive net present value using the well level operating expense, though the well level operating expense that she used is very close to my $379 that clearly shows that the group costs are in fact included, so there's no need to have any greater operating expense than that. She's got a lot of value to these wells. Here's her 5-year gross revenues. A lot of values, a lot of positive numbers. Now, if we look at Brian Hill.
Is this our date of discovery for an NOAV?
For what she's talking about?
They just testified that they refract the grant number 4.
Oh, sorry, hang on.
Oh.
Ms. Clark, you may continue. I think they didn't realize they had their mic off. On, rather.
Cool. So here is Brian Hill's analysis of KPK's wells. Many times you can see he has an even greater economic value on these wells than my own analysis. This is DeCono's witness, or expert, which I think is pretty interesting that oftentimes his value is even more than mine. Definitely not a lot more than what Miss Lencioni provided in multiple situations. So I think, again, the importance here is there's a lot of value here. There are positive economic values for these wells in question. Also looking at Mr. Hill's report versus mine and versus Miss Lencioni's, my decline curves and Mr. Hill's are pretty similar. The declines seem to align pretty well with the historic data. Miss Lencioni's are really steep, not standard. Here's the.
I'm here to object to this line of testimony. This is part of their case in chief. If we want to talk about an exhibit to Mr. Oborn's report, this is not rebuttal to our rebuttal case. So I think we're going way beyond what's allowed in this scope of questioning and presentation.
And I would say, Mr. Chair, that if the applicants are permitted to completely restructure their economics for all slides, for all wells, this is fair game.
Yeah, I will let it let's continue.
Again, this is a report in Mr. Obern's testimony that was submitted as an exhibit, so I think it's fair game anyway. Yeah, Mr. Hill and I have similar decline curves. Pretty flat decline on oil, really reasonable. Miss Lencioni is really steep. Again, this is Dacono's own witness that is in agreement with me that these wells have value and quite significant value. Similar with Frederick, here's just a summary table. Mr. Hill did not perform analysis for Frederick, so I don't have his information in there. Point being, here's KPK's NPV, KPK's gross. You all saw my decline curve analyses and where these numbers came from. Ms. Lencioni does have projected economic value for pretty much all of these wells. Quick note on the MITs on 901A wells. As Ms. Byrne testified, oftentimes a well does require a blowdown to set the plug to isolate perforations and conduct the test. None of these wells have downhole isolation, and so we would have to do that. And in order to do that, we would have to blow down the well, which does count as venting, flaring, production, whatever that is. And we are prohibited to do so under the 901A. KPK, as a compromise, did install continuous Braden head monitoring on these wells that monitor each annulus in the wellbore, monitors the pressures in each annulus. So we are seeing pressures on the wellbore, or the lack thereof of pressures. And that is the end of my rebuttal slides.
Ms. Clark, just a few questions here for you in follow-up. The slide, you might want to put it back up briefly if you can, but the slide that shows the field level costs that you put up on your screen, sorry. The only thing I really wanted to confirm on that was that that slide pertains to Exhibit 144, which reflects field level costs for all of Spindle. I'll let you elaborate.
Yeah, yep. This is Exhibit 144. I just in this presentation wanted to highlight the specific things. But yeah, this is the exact operating expense spreadsheet that I used in my decline curve analysis.
Okay. And Mr. Chair, I believe you had previously admitted all exhibits, so I won't seek to have it admitted. If you would, Ms. Clark, go to the slide that pertains to the grant number 1 well with the refrac value.
Sure.
And I just want to make sure the commission understands. Can you just explain kind of the scale on the what I would call the y-axis of this graph so that they understand the significance of the bump in production from the refrac?
Sure. Yeah. So this is a semi-log chart, so these are log every line here. Once you have the 10, this is now 20, 30, 40, until you get up to 100, and then you go 100, 200, 300. Anyway, so yeah, I mean, as I have in these bullet points here, you know, this pre-May 2008, we're sitting around 50 barrels per month, and that refrac doubles the production. So, I mean, even here, like I said, this is logarithmic. So this right here, this green dot corresponds to about 200 barrels in a month. So that's a 4x increase right away, and you know it drops down with hyperbolic decline after that refrac. But you know, it's held pretty steady. So I mean, yeah, this is a great refrac. This is a great example of what we can do when we refracture the Sussex.
Ms. Clark, one last couple more questions pertaining to 901A orders. Is it KPK's interpretation of those orders that producing, venting, and flaring are all prohibited for those wells?
That is correct.
And to your knowledge, has KPK received any advisement from staff at the director level, since the 901A order came from the director, that those things are permissible under the order?
We have not received any indication that that is something we are allowed to do.
Okay. I have nothing further. Thank you.
Thank you.
Great. Uh, let's see. Commissioner questions? Mr. Sura?
Could we have cross of this witness?
Oh, sure.
Appreciate it. Thank you. Just a few questions. You mentioned your lease operating expenses and you provide color coding for that. You heard Miss Letha's testimony about her revised lease operating expenses, did you not?
Yeah.
And you heard Letha Lencioni state that there were some that were there that she revised upwards, but recognized that you had included them?
Yes.
Okay. Could you please go to, or maybe you could just look, can you tell me how much you estimated per year for weed maintenance in your lease operating expenses?
Yeah, here, why don't I share my screen for you? Weed maintenance. $6,000 per year.
And you recognize that in the filings, nearly every well, with at least within Frederick, had weed maintenance concerns from some of the inspection reports?
Yes, there are weed write-ups and inspection reports.
Okay. In moving to the Netherlands Soil report, did you put the entire report into record?
I did not. That is confidential business information.
Did you supply the name of the author?
I can. It's Randy Green.
Did you ask, you did not ask the author to speak at this hearing, did you not?
KPK did not.
Okay. You did not supply any of the names of the wells that you had supposedly refract in this hearing prior to today? Did you?
I did not provide any list of wells that have been refract.
Okay. I've got no further questions, but I know that Stephen Lewis Prescott does.
Mr. Prescott?
Thank you, Chair. Good afternoon, Ms. Clark. Do you know why Mr. Hill was unavailable to present at this hearing?
I do not.
Did anyone get to question him about the report attached to Mr. Oborn's report?
No.
Do you understand why Mr. Oborn attached the Hill report as an exhibit?
Because he was presented as an expert in petroleum engineering and did the reserves analysis that was asked of him.
Do you recall Mr. Oborn saying that he just wanted to know which wells he was providing a report for?
Don't recall that.
And then you talked about the refrac on one of the wells, increasing production back in 2008. Is that right?
Correct.
Did KPK refrac any of the other subject wells in this hearing?
Not that I know of.
And most recently for that well that you had the graph for showing the refrac production, or the production after the refrac, most recently it was producing 1 barrel a month, right?
That's what it looks like.
Right down there at month 250. Okay. And how many wells are in the Spindle field again?
In all of Spindle, a little over 800.
Okay. And your costs in that exhibit 144, that was an average of, or that was the expense for all of the wells. That's essentially what you're calling field level for some of those costs.
The wells that I use for this analysis here are 779 wells. Those are the Spindle Sussex wells. All of Spindle encompasses some of our Codell Niobrara wells.
Okay, thanks for that clarification. And under group costs, the first one there's the battery flow line repair. The average reported period, you have 9,426. Is that a month, a year? What's that period that you're talking about there?
That would be per month.
Okay, I thought earlier you said the average reported period was a year and the total reported period was 5 years. Do I have that wrong?
The average, this is the average per month. The total reported is the total across the 5 years.
Okay. And so for that battery flow line repair, that 9,426, that's 11, $12 per well per month.
That's fair.
Okay. And did you tie any flow line repair costs to the specific wells at issue that have broken flow lines that have been broken and in need of repair for a few years now?
I included this cost, which is flow line repairs.
Okay. And so this just pertains to 779 wells. It doesn't take in the flow line repair cost for the specific wells in this hearing, correct?
This is our operating expense for the 779 wells that I show here.
Thank you. No more questions.
All right. Mr. Boudreau,
Yes, staff has a few questions for Ms. Clark, if that's okay.
go ahead.
Thank you. Ms. Clark, I'd like to discuss I'd like to go back to the MIT discussion you were having a little bit earlier. Do you know what a liquid unloading event is?
Yes.
And do you file KPK's Form 42s reporting on liquid unloading events?
I do not.
Do you know how many liquid unloading events KPK has completed in the last year?
I do not.
If I represent to you that it was about 270, does that seem accurate?
She just specified objection. She just specified she did not know how many were done. That would call for her to speculate.
If you know, if you agree, you can answer. If not, don't answer.
I don't know.
When KPK conducts liquid unloading events, does KPK control the emissions in those situations?
I would object. She's here for economic and analysis. She's not here for environmental analysis and to provide, what they do with certain events like liquids unloading. That's never been a part of her direct testimony.
I tend to agree with that.
Sorry,
Mr. Boudreau.
Mr. Chair, it's my understanding that Ms. Clark has filed Form 42s on behalf of KPK.
I believe I'm only the contact person on Form 42s. I am not the person signing it.
Thank you. But you are familiar with liquid unloading events, correct?
Sure.
Is that necessarily any different than the blowdown that would have been required to conduct an MIT to remain in compliance regarding the shut-in wells?
And I will object. She's here to testify about the economics, not the operation of the wells. That's outside of her direct testimony and rebuttal.
I believe this is relevant regarding Ms. Clark's testimony on MITs earlier.
Ms. Clark didn't testify to how MITs are operated or compliance with MITs. You're asking her to testify about events happening during MITs of which she would have no direct knowledge and never has represented any direct knowledge, nor has she had any in her direct testimony any knowledge of how the operations of MITs work either.
Mr. Chair, I believe she testified earlier regarding the ability to conduct MITs and emissions
I think you're
associated with
right. And so I think you do have an ability to go a little ways down this path.
Thank you. And this is my last question, and I'll be happy to repeat it if that helps, Ms. Clark. Are the liquid unloading events that KPK conducts necessarily different than the blowdowns that would have been required to conduct MITs for KPK to remain in compliance for the shut-in wells?
I don't believe so.
Thank you. No more questions, Mr. Chair.
Anything further, Mr. McGowan?
No, Your Honor. Or no, Mr. Chair. Sorry. Apologies.
You can come to Your Honor. It's fine. All right. Questions from commissioners for Ms. Clark. Commissioner Cross.
Thank you, Mr. Chair, and thank you, Ms. Clark, for being back here today. I just want to ask a couple clarifying questions. For one, you highlighted the definition of shrinkage from a textbook. Can you inform us all what textbook you are referring to?
Sure. It's Oil and Gas Property Evaluation by John Wright.
Okay, and you said, I think you called it the textbook. Are there other textbooks that you referred to, or that's just the one that you used in the past?
This is the one that I used in the past, particularly for this hearing, and so since I've had it in citations previously, I stuck to this one.
Okay, just want to make sure that we're all on the same page as to what you're referring to when we have snippets of information in there.
Yep.
And let's go back a little bit here about the refrac questions. You put up a matrix, I believe, that talked about the different rules when they were in place, and you said in 2008, yes, that's the one. Thank you. And you said in 2008, when these were done, reporting wasn't required. You filled out what you needed to, and I believe you said, I think you said the rules regarding Form 5As weren't there yet. And I just want to first ask, one, did you create this matrix?
No, this is an ECMC matrix.
Okay. And two, were you working with KPK or anywhere else in the industry in 2008?
I was not.
So how do you know what rules were or were not in place in 2008? Did you do any background research on this?
I did some reading on this, yes. I mean, I do know that frac focus wasn't created until 2011, so there's no way for us to have reported anything in frac.
And frac focus is fine, but I'm curious because you specifically said Form 5A rules, and I'm curious what Form 5A rule you're referring to, number one, and two, what research you did to know that the Form 5A rules were not in place at the time.
Yeah, 308B, I don't believe was in effect at that point.
Did you look at historical ECMC rules?
I did.
Okay. Those are my only questions. Thank you.
Commissioner Messner?
Thanks, Mr. Chair. Ms. Clark, I'm a little confused. Did you hear Ms. Burns' testimony?
Yes, part of it.
And Mr. Geronimo's testimony, who indicated that the Form 5As, have been in the rules since 1998.
I found something on the website that said 2012.
Okay. So Mr. McGowan had indicated that you were here to provide testimony on economics, correct?
That's part of my testimony.
Are you a regulatory expert for KPK? Do you do the rules and the forms, and do you have that expertise?
I do all of our 5As. I do all of our yes, I do a
So
lot of our regulations.
You do the forms then?
Some of them, not all.
Okay. And so are you familiar with Rule 903D1B, which is what you testified to regarding flaring and the off-ramps that would allow for flaring for certain circumstances?
I'm not familiar with that rule, no.
Okay. Thank you. That's the only questions I have.
Anything further for the witness from commissioners? Ms. Clark, thank you very much for coming back and testifying to us. We appreciate it.
Thanks.
All right. Are we at the place where we need to hear? So here's my plan. I think we're at closing statements. We're going to do those this afternoon, and then we're going to halt for the day, and we're going to come back tomorrow morning, probably at 9, for deliberations for commissioners. That'll give us one last little bit of time this evening to capture all of our notes. I do not recall what the order of a closing is. Mr. Sura, Mr. Schwarzenberger, do you guys know?
Mr. Chair, I do believe the hearing officer's order does address this, and I believe he did say that the applicants do their closing last. Do I remember that correctly, Mr. Prescott and Sura?
That's great.
That's correct.
All right. And then where does Mr. Boudreau go?
Yes, Mr. Robbins, this is Hearing Officer Smeltz. ECMC staff will close first, followed by KPK, and then followed by Dacono and Frederick.
Okay. Then let's take 10 minutes and let's take those closings up at 3:30. I'm going to encourage folks that their closings can be up to 15 minutes, but you do not need to use the full 15 minutes. And with that, we'll see you in 10. Mr. McGowan, just FYI, your video is still on. I don't know if that's purposeful or not.
It was not. Thank you, Mr. Chair. Appreciate that.
All right, it is 3:30. This is the Energy and Carbon Management Commission. We are taking up docket 2409002228. And we now are prepared to hear closing arguments, first from staff, then from KPK, and then finally from the city and town. So, Mr. Boudreau, are you ready?
Yes, Mr. Chair, I am. Thank you.
All right, the floor is yours.
Thank you, Mr. Chair and other commissioners. Staff began this hearing by explaining its limited role in this matter, and that is to make members of staff available to the commissioners for the purposes of providing information on potential threats to public health, safety, welfare, the environment, and wildlife resources, and also information regarding mechanical and flow line integrity. You heard Mr. Duranlo testify regarding both open and closed remediation projects associated with the subject wells, locations, and flow lines. Mr. Duranlo also testified regarding corrective actions from an outstanding Rule 901A order and another Rule 901A order which has been closed out. You heard Ms. Byrne testify regarding KPK's MIT history for the subject wells, and she also testified regarding the most recent 901A order regarding flow line integrity. Staff is not advocating that you order the subject wells plugged or abandoned, or that you order the subject locations reclaimed. Staff is not advocating that you do not order the wells plugged and abandoned. Staff intervened for the benefit of the commissioners, and we hope that you found value in our participation. In the interest of keeping matters short, I'll leave it there, other than to say thank you for the opportunity to participate.
Thank you very much, Mr. Boudreau. Appreciate the closing argument. Now, who's delivering the closing for KPK?
I am, Mr. Chair.
All right, the floor is yours.
Thank you, Mr. Chair and members of the commission. We know this has been a very long process, and we appreciate your patience and the opportunity to present KPK's case regarding the subject wells and the applicability of Rule 211. We understand this has been a significant amount of information and a time-consuming process, but we believe this to be a fairly simple and straightforward case. The petitioner local governments bear the burden of establishing that the subject wells and locations are either no longer used or useful, and that it is necessary and reasonable to plug and abandon the wells because of the needs to redress impacts to public health, safety, welfare, and the environment. And we believe, considering all the evidence in the record, petitioners are simply unable to meet their burden of proof. The case involves wells located in Tacoma and Frederick. These wells have been producing for some time, predating the home development. The city petitioners in this case testified they view KPK's wells located in their cities to be contrary to their land use objectives and would like to force KPK to plug and abandon their wells so that they can develop homes in the subject areas. This is evidenced by petitioners previously bringing this very same relief in KPK's financial assurance case, ultimately being dismissed, and thereafter certain relevant metro districts attempting to utilize eminent domain in the process of ridding the cities of these wells. Start with Rule 211. Rule 211 provides the basis for the petition and the standard under which the petitioners must satisfy their burden. There are two separate but equal components. Firstly, petitioners must establish that the plug-in and abandoning of the well is necessary and reasonable to protect or minimize adverse impacts to the public health, safety, and welfare, the environment, or wildlife resources. In other words, petitioners not only must establish there are present adverse impacts, but they also must establish that it is reasonable and necessary to force KPK to plug and abandon its wells in order to address those impacts. Alternatively, petitioners must establish that the wells are no longer used or useful. Importantly, under Colorado law, the terms necessary and reasonable serve as limiting principles. Further, the Commissioner's statement of basis and purpose for Rule 211 makes clear that the Commission has rarely required operators to plug and abandon wells pursuant to prior Rule 208, now Rule 211, and intends to continue exercising its discretion under Rule 211 only in rare instances when doing so is necessary and reasonable to protect and minimize adverse impacts to public health, safety, welfare, and the environment. This is a high standard for Rule 211 to force plugging and abandonment, and is evidenced by the only two recent orders issued by this commission pursuant to what is now Rule 211. In each of those cases, there were ongoing, immediate, and serious threats to impacts to public health, safety, and welfare in the environment that made it necessary and reasonable to require immediate action to plug and abandon those wells. Staff affirmatively demonstrated the existence of these impacts. The cases did not involve potential threats based on, for example, the absence of forms. These cases were similarly not based on impacts related to ancillary equipment such as flow lines, historical actions, or subjective economic analysis. Rather, each well had a pervasive problem that needed to be addressed by the Commission in a timely fashion. Further, in the only contested Rule 211 case, the operator needed 11 miles of flow line in a gas processing plant in order to produce the well and sell hydrocarbons. That's simply not analogous to the case here. In summary, we believe this Commission should look to already established precedent in evaluating this case, not seek to implement new standards that will undoubtedly be misused by the broad range of potential applicants under Rule 211. We also believe it's important to remind the Commission of the apparent pretext under which this proceeding was commenced, as been established by the local government's own email communications and testimony. The applicants would like to force KPK to leave their town and forfeit their leases and property rights to allow developers to secure the land and build homes. As the towns testified, they believe it's more economical to use this commission to enter an order forcing KPK to plug its wells rather than requiring developers to condemn the property and pay for it, or purchase KPK's property rights in a free market arm's length transaction. Effectively, they don't want to bear any of the cost. As you've heard, much of the future planned development overlaps current KPK locations. To achieve their ultimate goal of increasing home development in the locations owned by KPK, the cities are attempting to use this Rule 211 hearing by arguing that it is, despite all the evidence to the contrary or the absence of evidence, necessary to plug and abandon the wells. Used and useful. As noted previously, the petitioners must meet their burden by proving the wells are either no longer used or useful, or there are ongoing substantive impacts to potential public health, safety, and welfare that make it necessary and reasonable to order plugging the wells. Those are the two ways to do this. With respect to used or useful, we believe this is a clear-cut example of wells that have established an ongoing value, and the petitioner's arguments regarding used and useful do not meet the applicatory regulatory standard. The definition of used and useful, this is from the ECMC 100 series, means a well location or facility with well location or facility with or without associated wells that is currently being used or has an identified future beneficial use, which may be indicated by, among other things, production trends, plug-in abandonment, remediation, reclamation costs in relation to gross revenue, remaining economic viability, or other relevant evidence. It is a very broad statement with two different ways to identify being used or useful. It is the petitioner's burden to prove that the wells are not being used and that none of them have been identified beneficial future use. It is not KPK's burden to show that none of the elements apply. KPK prevails under the standard if any of the wells are in use or if one factor is satisfied for identified future beneficial use. Put another way, under the rule, KPK may establish that the wells are currently being used, in use, and if they have identified beneficial use, which can be done with any of the associated prongs of the rule. The interpretation that a well may not be plugged if it is currently being used or has an identified future beneficial use aligns with the canons of construction under Colorado law, specifically the last antecedent rule, which requires, in this circumstance, that the enumerated factors be applied to the identified beneficial future use. In other words, currently being used is one element, and identified future beneficial use is the other element, with that being proven by the subset of A through E. This is how Colorado law stipulates that rule is to be read. The substance of the petitioner's case for used and useful lies with their experts, specifically mostly Double L Engineering. The problem with the RLG's party's expert are almost too numerous to list. The most significant admissions include her own statements that she was hired to establish an outcome, not make a determination based on facts. Actual costs were not used in her analysis. KPK's established costs were simply disregarded, the actual operator of the well, and no effort was made to determine the validity or reach out to the operator. For many of the costs, she simply made them up to reach a preordained result directed by the applicants. The report utilized only 2024 costs while outright ignoring the remaining 4 years of cost data. In other words, the report's cherry-picked data. She utilized production numbers and established trend lines that did not follow the golden rule of decline curve analysis, which is an industry standard. She failed to account for factors such as COVID-19 shut-ins, 901A orders, and other shut-ins caused by service or downhole activity, thereby ensuring that production numbers would be significantly lower, non-representative of actual production. She used a 10-year decline curve for wells that have been producing for decades and ignore reservoir characteristics for the life of the well, instead focusing on recent production that was reduced due to the surface and/or regulatory factors. This is just a few of the many ways she ignored established industry standards and precedent, and also added in P&A's costs where KPK's expert established are capital expenditures and not included in economic viability per industry evaluation standards. More to the point, her report in total did not meet oil and gas engineering standards. Assumed remediation costs based on nothing more than rough estimates, not actual evaluation of the remediation projects, and then spreading those estimated costs among all wells as opposed to trying to review well-specific remediation costs. Stated that there is no refracturing value for the wells despite KPK having refractured 46 wells in the Spindle field, demonstrating refracturing value. This potential was not factored into analysis, as she admitted. Despite numerous attempts, they could not rule out enhanced oil field recovery or carbon capture as identified future uses, instead categorically labeling them with words as unlikely or difficult or improbable alternatives, essentially admitting that they are identified beneficial uses and she could not categorically eliminate them. That satisfies the rule. And finally, making significant errors in a report that it such significant errors in a report that it necessitated petitioners filing a new and substantially amended report with new economics for almost all wells. That included, for example, assuming a 95% royalty interest on gas production and an inability to determine what actual gross versus net revenues are. Based on these errors, along with others, this commission should summarily dismiss petitioner's expert report as unreliable and inaccurate. Notably, applicant's other decline curve expert, Brian Hill, whom they relied on, performed the very same analysis and found all the wells within Dakota to have positive economics. With respect to used and useful, there are two elements or aspects that must be evaluated when determining whether a well is used or useful. Pursuant to the rules, if the wells are either in use or if they have an identified beneficial use, they are not subjective to compulsory plug-in and abandonment. With respect to petitioner's arguments, the first and most obvious point is that the wells continue to be in use. That was admitted by their expert who stated they are in use, their own expert. The wells were in production prior to 901A orders and any other causes for shut-in and are still able to produce in paying quantities. Further, the wells are not subject to a 901A are in producing status, again, in use. These wells are thus productive and based on ECMC records in use and thus by definition used and useful under ECMC rules. I would point out that the petitioner's own witness acknowledged, again, these are in use. That is important. Next, KPK has identified multiple future beneficial uses. KPK's expert team testified that when taking into account the integrated nature of KPK's operations, the actual decline curve developed from an actual historical production numbers reflecting reservoir characteristics, economics of the well, refracs, possible secondary or tertiary development, and other possible economic uses such as carbon capture, which is possible, identified future beneficial use, even according to plaintiff's own experts. KPK's wells clearly meet the second independent element of the definition of used and useful. Again, KPK's expert testimony established the decline curve that meets industry standards shows remaining viability. The remaining reserves able to be produced. Multiple wells have been refracted and that potential still exists. The wells are likely to generate additional profitability pursuant to enhanced oil field recovery, and CCUS is a viable future possibility based on multiple factors, including but not limited to geologic formation, proximity of the wells to sources of carbon emissions, and other utilization factors. It should be noted that the rule does not say beneficial uses must be probable. Rather, it says future beneficials need to be only identified. Enhanced oil field recovery and CCUS clearly qualify. Even assuming the expert report maintains some integrity after its multiple significant errors, the numerous developer agreements submitted in the record establish a market value of between $200,000 and $250,000 per well in value. These agreements are free market transactions between willing buyer and seller. No one's forced to take an agreement. These agreements and they take into account multiple factors. Similarly to a housing market, comparable transactions are, as petitioner's expert John Ober noted, a valuable tool in determining value. Further, Ms. Lencioni said that these comparable transactions reflect the best evidence of value. Again, their own experts established that there is value in these wells. Thus, there's ample evidence that the wells and locations have significant value, also satisfying the definition of used and useful under those rules. The value paid to KPK in these agreements incorporate remaining economic viability from production. The value of the surface rights, easements, and amongst other things. These agreements are not solely based on plugging costs, rather the entire remaining value based on the market that the wells and/or locations hold. The market works in this instance whereby sophisticated parties on both sides freely enter into transaction, analyzing business risks and costs, and determine the price is appropriate and justifies entering the agreement. Nobody is forced into agreement, rather it is a beneficial transaction for both parties. This includes clients of petitioner's own attorney, Mr. Prescott, who only recently advised and had his client sign such an agreement, further cementing the established market value that the wells and locations have remaining economic value. Under the definition used in ECMC rules, this means the locations in the wells are used and useful pursuant to the 100 series definition, and it should be noted that this market value establishes it whether there's a pending transaction or not. This is not a legal context relating to fair market value. There must be pending transaction in order for comparable transactions to be relevant. Stated differently, comparable transactions are the most relevant evidence in any fair market value inquiry. The second basis under the Rule 211 requires petitioners to establish the plugging and abandoning is reasonable and necessary to protect or minimize adverse impacts to public health, safety, welfare, and the environment. Again, necessary and reasonable. To be clear, it is not just whether there is an impact to public health, safety, and welfare or an adverse condition, rather that it is also necessary and reasonable to require plugging and abandonment to mitigate these adverse impacts. Again, petitioner's argument fails as they presented no evidence on that very issue. First, local government's petition for hearing contains numerous assumptions and inaccuracies or old allegations that have long since been resolved. This includes petitioners' attempts to assign, for example, historical pits to wells that KPK does not and has not and never owned. Further, the petitioner makes allegations about alleged non-compliance, many of which are, even if taken as true, despite being unadjudicated, Tier 1 violations that, per the ECMC's own handbook, pose no threat to public health, safety, or welfare. That's the ECMC's own rules. Petitioners also attempt to bring up older allegations or NOVs that long since been resolved. If we recall, according to the state's witnesses, Mr. Naranlo, resolution establishes that an issue no longer poses any threat to public health, safety, and welfare if it's resolved. Indeed, petitioner's own witness acknowledged that the petition was partially based on an attempt to establish historical violations and patterns, arguments which should be disregarded according to staff's testimony. Petitioners further attempt to argue the location of the wells are an issue, but fail to acknowledge, and their witnesses testified to, that the homes near the wells were built near pre-existing development. In other words, petitioners are arguing that wells simultaneously pose a public health, safety, and welfare risk, but not significant enough for the local governments to contend to stop permitting, which they've continued to do, the building of homes nearby the existing wells, which according to petitioners' own presentation was happening as recently as just last year. Nor has it stopped the petitioners from approving plats that overlap KPK's own locations in anticipation of future development. It appears counterintuitive to permit homes or plat developments near wells that are such alleged threats. Petitioners also try to make unsubstantiated allegations that KPK is in violation of certain ECMC rules. But we should point out many, if not all, of these allegations are pure speculation. They have not been found to be in violation of nearly any of the rules, and these inspections that do show compliance issues are Tier 1 violations or Tier 2 violations with no indication of public health, safety, and welfare aggravators, which is noted when those are issued, and then long since addressed and subsequently not present on the most recent inspections. This is in contrast to petitioners' attempts at cherry-picking inspections to make it appear as though KPK is out of compliance. We have illustrated these discrepancies in the PowerPoint on a well-by-well basis that we submitted. Additionally, it is important to note that while petitioners had no expert witnesses or witnesses qualified to testify to public health, safety, and welfare, KPK's witness, Mr. Peterson, is a scientist and an expert, as acknowledged by this commission, with an extensive background in public health and oil and gas. Mr. Peterson's expert testimony addressed each of the ongoing remediation projects current KPK has outstanding and established that the remediation projects do not pose a threat to public health, safety, and welfare. For indeed, they are in remediation projects that are ongoing. Testing of forms, submission of forms, possible inaccurate information, and other ancillary reasons have caused denial of closures or Form 27s, but it's not because of an imminent threat or a threat of the kind that requires plugging and abandonment or makes it necessary and reasonable to plug and abandon the wells. Rather, Mr. Peterson's expert testimony establishes the projects are ongoing projects and the status of those projects is not out of the ordinary. That was also acknowledged by the state, which stated that it does sometimes take months or even years. In each instance, KPK addressed the immediate problem, such as a spill or leak, with efficient and effective strategies to ensure that any ongoing and immediate threat was neutralized as soon as possible. There are no ongoing leaks or spills. The initial threats being contained was confirmed by both state staff as well as KPK's expert witness. Whether that action was shutting in a flow line or immediately taking steps to excavate soil, in each instance, the pervasive and immediate threat was addressed with due care and speed. There have been no allegations to the contrary on that. In addition, the state's witnesses testified that indeed it's not uncommon for an operator to have multiple projects and for those projects to be going on for some time, even years. Remediation projects alone do not establish that it is necessary and reasonable to require plugging and abandonment of a well, especially those when they're related to flow line issues. It should be added that there are already remedies available for the petitioners seek if there is in fact a public health, safety, and welfare issue. The commission can issue a cease and desist order and secure an injunction if needed. None of those actions have been taken because they're not necessary. KPK has, in good faith, diligently pursued completion of the remediation projects, mooting any need for either case, and either cease and desist injunction or here in order to require plugging and abandonment. Finally, as established by staff, many of the line issues brought up by the petitioners are related to the wells or location. Rather, they're related to flow lines, which are ancillary and separate pieces of equipment with their own ID, and as we heard today. In other words, as agreed to staff, Ms. Burnett during testimony, for example, KPK could permit and reroute production to a tank battery, which would eliminate all of the issues on the flow lines and still allow for the wells to continue operating. Again, Mr. Ronley testified today that an issue with a flow line does not equate to an issue with a well. That doesn't necessarily require it to be plugged and abandoned. In many instances where the problem was related to a flow line, those problematic segments were directly replaced by KPK, ameliorating any ongoing or future issues. In other words, if there's a flow line issue, the appropriate remedy is to address the flow line, not plug the associated well or associated wells with that flow line without evidence being provided to establish the well itself is an issue. No such evidence has been presented. Even in the instance the commission were to issue an order for plugging and abandonment, it would not address the underlying remediation projects, which is also why it's not necessary and reasonable. Put another way, those projects still require certain compliance thresholds be met, which will take time, mooting the point of issuing an order. If the goal is public health, safety, and welfare, it makes sense to order plugging and abandonment of wells or locations for issues with ancillary equipment and require KPK to complete the process that they would otherwise be already be required to complete and are in the process of doing. In other words, it serves no purpose. Issuing a P&A order is neither necessary nor reasonable because it would not change the work and it would not change the process or the timeline for completion of the work. I believe you stated it well, Mr. Chair. Oil and gas operations in and of themselves necessitate some level of impact. The burden is on the petitioner to show that level of impact requires that it's necessary and reasonable to plug those wells. I also want to add real quick, 901A states immediately that you must suspend all operations, and it means you must shut in. You cannot unload a well if it's shut in. It is a prohibition on selling gas. And then, yes, it also eliminates the possibility of 903 to comply. In other words, if you operate under a shut-in order 901A, you cannot vent, flare, unload, or sell gas, which eliminates the possibility for an MIT. Regardless of what other options are available, a shut-in order, we would immediately have to violate a Tier 3 order in order to comply with an MIT. Further, as admitted by staff, in two separate instances, the failure of an MIT in and of itself does not establish a public health, safety, and welfare threat. It only establishes that an MIT has not been done. In some, there is absolutely no evidence or facts presented by the petitioners establishing that it is necessary and reasonable to plug and abandon the wells for public health, safety, and welfare reasons. There has been quite a bit of testimony surrounding public health, safety, and welfare, yet none of it pointed out why plugging and abandonment would solve the problem or is necessary and reasonable. State testimony just illustrated most of the issues were related to flow lines, and both the state and petitioner witnesses acknowledged that the flow lines do not necessarily impact wells, and no evidence showing the wells have been an issue wherever they have been presented. Further, open remediation project is with flow lines, so again, no testimony and evidence was presented illustrating why a well being plugged and abandoned is reasonable and necessary to address the issue. In sum, even if the petitioners would have met their burden to establish there is an alleged public health, safety, and welfare, they have not established what those threats are, how significant those threats are, but that it is necessary and reasonable to require plugging and abandonment of the well. Finally, we believe it is appropriate to briefly address the underlying policy. Rule 211 is intended allow the commissioners to assist with the resolution of incidents and/or wells that prove to be pervasive, ongoing threat to public health, safety, and welfare. Specifically, those wells where local government, for example, has had a well with a serious compliance issue that cannot and will not be addressed. Just like the previously issued orders we discussed earlier, the threat must be tied to a violation, be ongoing, be immediate, and a threat, i.e., necessitating and being necessary and reasonable to address. The threat must be something more than generalized, cumulative, and or speculative, which is what we have here. Hence the qualification that it must be necessary and reasonable in the rule. Not just have an alleged adverse impact, it must be a two-part inquiry and both elements must be satisfied. Any alleged adverse impacts to public health, safety, and welfare, most of this kind and character that make it necessary and reasonable for the commission to enter a plugging and abandonment order. And this is why the standard is not simply impacts, it is impacts that require action. All development, just not oil and gas, would technically be construed in a way that could be perceived as having an impact. As the state testified, for example, they view all remediation projects as an ongoing impact. If this is the applicable standard, then every oil and gas operator with a remediation project, no matter what stage of remediation, amount of work already completed on the project, or otherwise compliance measures, would be subject to a Rule 211 hearing. This is an untenable and unreasonable standard, one of which would expand the rule far beyond its intent and language, as was articulated by the statement of basis and purpose during the rulemaking and the discussion by this commission during the rulemaking. Thus, necessary and reasonable, the second part of the analysis must be satisfied. In other words, to satisfy their burden and comport with the plain language and spirit of the rule, petitioners must not only establish harm, but that plugging and abandonment is necessary and reasonable in light of the facts to protect public health, safety, and welfare. Petitioner's case, they are unable to meet this standard. Petitioner has proffered exactly no evidence or testimony regarding
Mr.
the
McGowan,
necessary.
you need to wrap up, please.
I can do that. Yes, sir. We will just say petitioners do not seek a remedy of an identifiable issue. Rather, they seek to forcibly close 42 of I believe it's 42 now, of KPK's viable oil and gas wells. And this is based on a questionable economic analysis and speculation of general analysis. I appreciate your time. Thank you, Mr. Chair.
All right. Mr. Sura and Mr. Prescott and Mr. McGowan, I'm going to give Sura and Prescott the same amount of time that I gave Mr. McGowan. In large part, this is due to Mr. Boudreau being brief and not taking his full 15 minutes. So you all owe him a beer the next time you're out at a bar talking lawyer things. Mr. Sura and Mr. Prescott, you have 24 minutes, 13.27 seconds.
Thank you, Chair. I'll share my screen. Thank you, Chair and Commissioners. You've heard a lot of evidence and testimony. You've been diligent in listening and asking questions, and it's appreciated, I'm sure, by all parties. I will attempt to be swift in my summation of the evidence. You have a regulatory framework that's pretty straightforward. You have a definition of user useful that provides the objective criteria to apply to determine whether a well is user useful. And you also have more in your discretion whether a well is a threat to public health, safety, welfare, and the environment. And it's an either or. You can order a well to be plugged if it's not user useful in your determination or a threat to public health, safety, welfare, and the environment. Just some history of how we got to the rule as is written today. You'll recall the mission change rulemaking, where rules were essentially rewritten to ensure the protection of public health, safety, welfare, and the environment, indicating to me that violations of rules constitute potential threats. It was in the financial assurance rulemaking that the user useful definition was fleshed out and the 5 elements were identified. And it's in the statement of basis and purpose that you find some color for these elements. Production is extremely important for consideration. It's often the only source of revenue from a well. A strong indicator is also whether remediation, plugging, abandonment, reclamation costs exceed gross revenue. The commission is supposed to focus on relevant evidence, and I think that's key to a lot of the evidence that you heard, much potentially not relevant. And it also talks about how the operator is recorded to show as an affirmative defense each of these elements as well, meaning we are not the only ones with a burden in this case. The applicant's case of using useful started with Mr. John Oborn recognized as an expert based on his skill, experience, and other factors. And, previously at the financial assurance hearing, he had determined that all the wells are low producing and no longer used or useful. And in this case, he presented a report for the 17 wells at issue in this case, confirming the same. He talked about market for these wells, none exists. Salability of these wells, not existent. A typical transaction that he could find would be an exchange of these wells for $0 in exchange for all of the environmental and plugging liability that they come with. In his opinion, a prudent operator would plug and abandon them. He also talked about how all the wells are overdue for an MIT, and he testified that MITs cost $35,000. These are costs that KBK has not incorporated. Ms. Lencioni has 40 plus years of experience doing exactly this, looking at the economics of a well, forecasting the future. She's done thousands of decline curve analyses for the feds, for banks, and for the industry, working interest owners and interest owners as well. She was qualified as an expert to give opinions on all 5 use or useful factors. She had a method for analyzing each of the 5 use or useful factors. She made sure she understood the factors before even beginning with her reports. She looked at trends and recognized that while wells produced 25 years ago, they haven't produced like that since then. She looked at the costs presented by KPK and recognized that they were too low and didn't account for necessary costs. She talked about well level and field level costs, and that its standards include both, and that when including field level costs, accurate and correct field level costs, none of the wells are profitable or have been profitable. The second element, plugging, abandonment, remediation, and reclamation costs for 5 years of 5 years of gross revenue. The best evidence you heard was from the financial assurance hearing where staff presented estimated remediation costs outstanding for KBK projects. And that's what Ms. Lencioni used to determine on a well-by-well basis what those costs are. She also relied on the single well financial assurance decision determining what KBK owes for financial assurance for each well. And she determined that none of them have gross revenue that exceed the liabilities associated with these wells. 18 of the 42 wells, nearly half, have been shut in for more than 3 years. There hasn't been any work or projects to make them economic. I think KPK argues that wells produced recently and therefore they're used. Our position would be that a well that's not economic, even if it does produce, if it's operating at a loss, that's not used. That's a well that should be plugged, and that's why prudent operators are constantly plugging such wells. Ms. Lencioni considered and rejected KBK's proposals for speculative projects, refracs, injection, enhanced oil recovery for numerous reasons. She explained why these are not feasible. It's not her speculating. She determined that these are speculative projects. They're all nearing 50 years old. This factor kind of is a culmination of the other factors, which all say that there's no economic viability left. And with as well as age, the risk of costs, maintenance costs, degradation of the materials, the wells themselves, risk of spills, they just increase. Suffice it to say that the wells just get worse every year, not better. Applicants presented evidence related to threats to public health, safety, welfare, and the environment. Again, I directed to the mission change rulemaking, talking about ensuring that the rules comply with the statutory changes. Statutory changes essentially requiring the commission to redraft rules to ensure that the rules are in place to protect public health, safety, welfare, and the environment. So every time we see KBK violating rules, we have to be cognizant of the potential threat. The 901A orders seem to be disregarded in what they say by KBK, but if you read them, ECMC staff found in each instance that KPK's subject wells, flow lines, facilities are threats to public health, safety, and welfare. Unfortunately, KBK has not been incentivized to comply and clean these up. I'm going to try to summarize these just for expediency. Big issue here is all these wells, when they're shut in, they're required to have a mechanical integrity test within 2 years. None of them have. If a well has been shut in for 12 months, it's inactive and it has to be plugged within 6 months unless financial assurance is put up for it. Many of these wells are inactive. There have been an insane number of spills in Tacona and Frederick over the past 6 years. They're in subdivisions, near surface water, in a driveway. This is a big driver for the commission or for the local governments to be here. These open spills, it seems like one step forward, 2 steps back. Every time KPK closes one, few and far between, we see more pop up, sometimes 2 in a day. You heard testimony that KPK doesn't give notice to local governments when spills are identified, that a lot of the spills are not even identified by KPK, but by third parties. We know that under the 901A order from 2024, KPK's flow lines in Tacona and Frederick were found to lack integrity. And it's these flow lines that are one of the single biggest problems. They're everywhere. They're under wetlands, streams, roads, schools, yards, parks. They're largely unidentified. We heard testimony from Mr. Peterson about a flow line being hit because no one knew it was there. The evidence that we presented shows that when there is a spill with a flow line, 3 or 6 feet of it's repaired, but the rest of it's still there. The location of these wells are a big concern, next to schools, playgrounds, etc. KPK is saying that this was built after their wells were drilled. Well, the rules have changed significantly since these wells were drilled in the 70s. Under the current rules in a closely regulated industry, an operator knows that rules are subject to change. They need to comply with them. Under the current rules, these wells are largely non-compliant. The testimony explained how Tacona and Frederick identified the relatively few KPK wells in their communities to proceed in this hearing, the lowest producers, the most dangerous locations, the most ECMC rule violations identified, the 901A orders, open remediations with little or no progress to closure, MITs in inactive status without any plugging occurring. We're not new to oil and gas. Frederick and Tacona has grown up with oil and gas. That's why we know the difference between a prudent operator and KPK. ECMC staff presented and I think very succinctly showed why these wells are threats to public health, safety, welfare, and the environment. 13 of the 17 wells in Tacona still have at least one, if not more, open remediations. 6 wells in Frederick have the same situation. The lack of quarterly reporting is very concerning to staff for obvious reasons. The lack of flow line integrity testing being uncompleted, the lack of MITs that are required. Essentially, KPK is providing no information that's required to provide to ensure that these wells are compliant with the rules and safe to the public. KPK's case. They want to tell you to ignore recent production, rely on production trends from 20 or 25 years ago to predict the future production. They want to argue that their reserves are highly valuable, yet the wells haven't produced. They want to argue that their operating costs are lower than others because KPK has subsidiaries. Same thing we heard Mr. Kaufman talk about in the financial assurance hearing and repeated it here. These are internal transfer prices. It's numbers they decide. They essentially make up these costs and then report them with no accountability. They don't have working interest partners. Nobody's looking at these costs. These are just numbers KPK is putting onto spreadsheets and not presenting as evidence to you. So the theme of this, and a theme through a lot of their testimony and evidence, is trust them, but don't verify it. Meanwhile, these costs were already, similar costs were already rejected in the financial assurance hearing by this commission. And again, without JIBs, there's no accountability for these costs. Ms. Clark's forecasting, again, it ignores the past 5 to 25 years. For every 100 months, we're talking about 8 1/3 years. And, these are just 6 examples. You can look at any one and see that, the reliance is on past production when it was higher, when the wells were younger, ignoring what the wells have been doing over the past 5, 10, 15, 20 years. We didn't hear any evidence regarding this factor for use and useful except gross revenue. The actual costs associated with remediation, reclamation, abandonment, plugging, nothing was presented. Mr. Kaufman did say that all available capital hasn't been spent on remediation and compliance in the past 5 years to, I believe, explain why they haven't conducted any projects or spent any money otherwise to get these wells to be as productive as they assert they can be. Didn't hear anything about costs to fix the open remediations that remain. Again, here's a theme that we hear a lot. If we don't report, there's no evidence of wrongdoing. We just heard Mr. McGowan state essentially that. If you don't know something's wrong, you can't rule that something's wrong, whereas I think it goes the other way. If you're not complying with reporting requirements, something's probably wrong. KBK argues that the ECMC made us shut in the wells, which is why they're not using them or developing them. It doesn't explain the lack of economic production prior to the 901 orders, and it ignores the significant violations of ECMC rules that result in the 901A orders in the first place. Again, they presented various projects. It's the same story that they presented in the financial assurance hearing that's already been rejected. They don't give us the actual costs to do any of these things. They don't identify or discuss the true real-world hurdles to implement any of these like Ms. Lencioni did. They rely on the refract potential on a report that they won't even provide to you or to us. Same thing. Trust but don't verify. Other relevant evidence, they really want to focus on the fact that developers, landowners who need to proceed with their development, get approvals, clean up the land in order to get the approvals, remove encumbrances, that they're essentially trapped to do a deal. And I cite to you, we heard a lot about what an arm's length transaction is and what a market value is. I cite to you this case from the Colorado Court of Appeals in 2013, which tells you that it is the most probable price which a property should bring in a competitive and open market under all conditions requisite to a fair sale, the buyer and seller each acting prudently and knowledgeably, and assuming the price is not affected by undue stimulus. I think all we have in those transactions are undue stimulus. These developers don't have professional engineers or oil and gas experts on staff. They don't know why KPK is charging what KPK is charging. KPK is saying don't take away their sole revenue source. This is how KPK makes money, and it's not permissible under the user useful regulation. KPK largely ignored the factors or provided evidence that is largely irrelevant to these factors. Mr. Kaufman talked about how in some cases, like for these wells, KPK curtails production to hold the leases. Colorado law is very clear. To hold a lease, it needs to be paying and producing quantities, i.e. economic. You can't hold leases with uneconomic wells. Mr. Kaufman explained one example of a well that KP plugged by his own choice. Listen to his explanation of that well. It is each and every one of these wells. Mr. Kaufman talked about KPK discussing grants and opportunities for the new projects. Again, no proof. They don't have the grants. He told you that. And it's the same thing we heard 2 years ago. Then you just heard a couple hours ago Ms. Clark testify about erroneously, or in contradiction to staff anyway, about whether they can conduct the MITs that haven't been conducted under 901A orders and what the rules actually said back in the 2000s. KBK argues that rule violations that have been corrected are not relevant. We believe this misses the point. KBK has consistent material rule violations, which, coupled with their financial condition, is a threat to public health, safety, welfare, and the environment. KBK argues that the wells have mechanical integrity, yet they haven't completed mechanical integrity tests. We have from the Wellbore Integrity's statement of basis and purpose the importance of wellbore integrity and proving it. Ms. Clark talked about the gaps in production of oil as there must be a problem downhole, as if this is normal. as if no oil production for 5 or 10 years is fine, and maybe they'll figure out what's wrong with it someday. Again, the theme is trust, don't verify. KPK argued that they cleaned up all their spills in contradiction to ECMC staff. If this were true, then we would expect to see timely reporting. Mr. Peterson has not worked at KPK since 2024, so he can't state what the current state is. I do want to hit on a point that Ms. McGowan brought up, that the earthen pits aren't theirs. We have an exhibit in the record showing that KPK acquired all these wells and associated facilities with no reservation of earthen pits. The KPK's evidence is that the earthen pits are not labeled KPK on the ECMC website, and that just means that, again, KPK didn't require the necessary forms to state that they are responsible for these. The title to these falls to KPK. Again, we heard evidence that KPK does not actually know where their flow lines are, that their flow lines get hit, they break because someone didn't know where they are. The fact that that has happened means that every flow line in these communities is a threat of somebody doing work and running into a flow line. We heard testimony about flow lines being upgraded, but no real explanation as to when, where, how, or why the cities and town didn't know that it was happening. We heard about inapplicable EPA regulations. We heard an argument that there aren't clear regulations in the Act or the rules. I believe that the Act is very clear on defining minimized adverse impacts. They argue that if an open remediation is an adverse impact, then every operator is in violation. That really ignores Rule 211 and the definition of minimized adverse impacts. Our closing request. You're being asked to complete an analysis as to whether each and every one of these 42 wells is used or useful, or a threat to public health, safety, welfare, and the environment. You can have an order that says some are and some aren't. Some need to be plugged, some don't. For each well that meets either standard, we ask that you order it be plugged within 12 months and cleanup be completed as to the remediation. Otherwise, there's a risk of KPK abandoning these wells without plugging them, and a continued risk to public health, safety, welfare, and the environment. We believe the only competent, relevant evidence submitted supports finding that each and every one of these 42 wells should be plugged under the rules. Remember, the industry is watching. If this does not qualify, if these wells do not qualify as an appropriate application of Rule 211, it's a message to other operators that KPK's operation and conduct is acceptable in Colorado. Thank you for your time and your attention.
All right. Thank you, Mr. Prescott, for the closing argument. Let me stop the stopwatch. Okay, we've got the closing arguments submitted. As I mentioned earlier, it's my preference that we break for the remainder of the afternoon, despite the fact there's not much left in terms of actual time within the day. I would be comfortable coming back at 9 tomorrow. We have a hearing at 10:30 that has nothing to do with this matter whatsoever, but we're going to be in a Zoom meeting at 10:30. If folks are comfortable with that, commissioners, I would suggest you look over your notes this evening and let's come back and start deliberations at 9 a.m. Yeah, Commissioner Messner.
Thanks, Mr. Chair. Do you think we have time between 9 and 10:30 to conclude deliberations? Because I would want to conclude that before breaking it up in the middle. Otherwise, it may make sense to do deliberations after the 10:30 item, but we could be done by 10:30. I'm not sure how long that might take, but
Yeah, I'm not sure either. Hadn't thought about if we're not done, then needing to stop and start. I do want to get done tomorrow, for sure. Hearing doctors.
Only other option I was thinking of is that we would start at 10:30, do the first item, and then just go into deliberations immediately after that, and then
Yeah.
that would be plenty of time. But I don't know what people's schedules are, so I don't know.
So I've got the day set aside because I penciled it in just in case. Our other commissioners, do you have the full day? Okay. Well then, Commissioner Messner, I think that's probably a smarter idea. Why don't we start at 10:30 with the Gallatin report, and then we will go into this right after. Mr. McGowan?
Yeah, just a quick note or question, Your Honor. I keep calling you Your Honor. I'm very sorry. Um, so just a quick note. Actually, we have a status hearing that will take not very long. Actually, in another case related to the ECMC and KPK. Are you comfortable if only one of the attorneys is here for us or any of that sort? I mean, I just didn't know how you wanted all that because I've always been typically here during deliberations. But are you comfortable if one of us drops off for another hearing? And I know my co-counsel also has a meeting. So is that acceptable to you? I just want to make sure that's
Yeah,
okay.
that's
We're fine. We don't have any issue, but I just want to make sure
yeah.
you're okay with it.
I'm okay with that. I'm not planning on entertaining additional Q&A with witnesses or attorneys, and so it's really just going to be the five of us deliberating. The deliberations will make their way to our docket, and so you can always go back and listen to our words of wisdom. So yeah, I think that's fine. Let me just make sure. Mr. Boudreau, does this work for you?
Yes, Mr. Chair, that works fine. Thank you.
And Mr. Prescott and Mr. Sura, y'all good with this plan of action?
Yeah, thank you.
I
That's
think
fine.
the first matter's roughly 30 minutes to an hour. I don't know, but it's something like that. So we will probably take a short break after that, and then we'll start in with you. So y'all can be doing something different and keep your computer on and just watch for when we get started if that works for everybody. All right. We will return at 10:30 in the morning for the report and then the finalization of docket that ends in 0228. Thank you, everybody. Have a good evening. We'll see you in the morning.